by this bench.
Yes, my lordship,
But CMAPL, the determination has been changed. CMAPL has to come before the assigned bench.
yeah, this is assigned, your lordship. Here, my
You are not getting,
case,
sir.
case was dismissed because
Sir, if you don't listen, sir, it will not register. There is a subject matter assignment, which is also determination or roster. Three things.
my lord.
That is one way of looking at it. Second aspect, CMAPL was earlier listed before the judge who had passed the order.
My,
Am I clear?
my,
Now, after the latest notification, since last 1 year almost,
my lord.
the restoration will go to the assigned bench. So that is how I asked you that whether the subject matter is my assignment.
No, man. But you, by virtue of your lordship, saw it
Kindly
as-
check that.
Yes, yes, I'll check.
Kindly check because because special benches need not
Yes,
be formed.
but it is not assigned to your lordship because
Then I do not have the assignment of taking of that matter. Please check it.
another problem is in another matter, my lord. During the year April 2025, the service matter, education matter was assigned to your lordships, as well as also Honorable Justice B.P. Satpathy. What happened was one matter came to your lordships, and my associate wrongly said that for us it is to be listed before Honorable Justice B.P. Satpathy. By mistake, it has come. But your lordship has passed some order again directing that it should be placed before Honorable Justice B.P. Satpathy. Anyhow, my lord, but again it
I
was
don't pass such wrong order.
not wrong order. Your lordship, I have
That is how I dictate the orders in open court.
no, your lordship.
My court is live in YouTube.
No, but
So whatever was and also I trust the lawyers.
No, no.
Whatever is being told
Also,
by the lawyer, I will follow that.
no, he said by mistake that perhaps it is
So
not.
that the law, the judge cannot do anything.
No, now my lord, again it has been directed to be listed to your lordships. If your lordship will
Who
tell,
has directed?
my lord, will.
I will never assume the jurisdiction of the Honorable the Chief Justice for directing matters to be listed
My
before
lord,
a single bench.
my lord, I will.
So you read that order?
Yes, my lord, your lordship's order. Before the list is called, that was order dated 8/4/2025. Before the list is called for matters to be taken up, the Law and Council for the
This is typical my order because I will reflect whether it is mentioned or it is reached. Yes, before the
Yes.
list is called.
submits that this bench is not assigned to hear the matter as the subject matter of the petition is education service, and liberty may be granted to move the assigned bench. So
So then kindly read, sir. Don't add to my order.
serial number 2 assigned of this bench indicates the following two some single judge WPC matters. The entry in the assignment would include single judge WPC matter pertaining to education service. Apparently, Law and Counsel for the petitioner does not wish to argue the matter. So, when your lordship directed matter stand adjudged liberty to mention. It
So
would
when I was not having a single judge assignment, and the Honorable the Chief Justice says that some writ petition.
yes.
So that is how I have a determination of every
It
matter.
is totally our fault.
No, not fault, sir. Not
Now,
fault.
my lord, Honorable
And this
Justice-
is not the only order in your case because now suppose I record.
Yes.
Suppose
My lord,
you have to listen, then it will register.
My lord, Honorable Justice B.P. Satpathy has said when it was listed again, the matter is taken up through hybrid arrangement such had in view of the nature of order passed by this court on 15/4/2025, let the matter be placed before the bench in question. So apparently now, my lord,
That's he cannot direct.
he
That's
just
to go to the Chief Justice.
So my lord, what?
15 for order is by whom?
My lord, 8/4/2005, your lordship has passed this order. Again, my lord, on 13/5/2025, it was listed before my
You
lord.
have missed the point actually. What is the point here?
Point is, my lord, is to be listed.
No. Suppose you say something that the matter is not in my determination. If I record that, I have the responsibility of checking the list. I have checked it. It is my determination only. I cannot say. Once the Honorable the Chief Justice says the matter shall be some writ petition matters, I cannot say since I like Mr. Jena, I will take Jena's matter, and I do not like Mr. Mahanti, I will not take his matter.
My junior.
So junior and senior, it doesn't make a difference. And as far as roster is concerned, I am yet to have that authority. I do not have that authority. I cannot direct matters to be listed before me,
No, that.
or for that matter before you. So I have dealt with your submission,
Man.
the learned counsel submission, that I do not have the determination of taking up of the matter.
If you listed before your lordship, then your
Cannot, sir, cannot. Unless it is assigned to my bench. And
Now it is not assigned.
that was changed almost 20 years back. Maybe 15, 20 years, almost 20 years back. Earlier, there was no roster kind of situation. After the roster has become, then the Chief Justice is the master of the roster. He will assign matters. He had assigned me writ petitions.
No, since
So I cannot distinguish because
that is the problem. The matter is not being listed. That is the problem.
that is not the problem. The problem is that the steps are not being taken to the matter to be listed. Because suppose I will direct the matter to be listed before Honorable so and so judge. I cannot do that.
No, your lordship.
It has to go to the Chief Justice. So have you taken my matter to be placed before the Chief Justice?
No.
Any steps? So that is how it is not being listed. I cannot determine. I am yet to have that.
No.
I don't wish to have that also. That's another thing. So anyway, I have no interest in taking up or not taking up any matter.
No, at least.
But the problem is, once I say that it is not in my determination, it is my responsibility. So that was not a correct submission. If some writ petitions is mentioned, then what was the order on the next date? 15-4, we are saying. 15-4, which order?
15-4, Honorable Justice V.P. Satpathy has passed the order that after seeing your lordship's order, in view of the nature of order passed in this court on 15-4-2025, 15-4, same bunch as let the matter be placed
15-4, what is the order I am asking you?
15-4 order is not available.
Then you have not seen also.
That I will answer.
Even if the Justice Satpathy has directed a matter to be listed before me, I cannot take it up.
No, here
I have strong liking for taking up any matter
concerned
directed by any court, any
Yes,
judge.
I will make a
But
mention.
the problem is that the Chief Justice has this prerogative.
That I will make a
So
mention
that-
about the Honorable Justice.
Not mention, you have to move it in before the registry to place the matter before the Chief Justice. Assignment is not done in the court.
Yes.
Yes, next.
Beg your pardon for the indulgence, Your Lordship. There is a transfer petition, Your Lordship.
So you file the memos, it will be listed.
Lordship. I
Give your memos, please.
transfer my please, ma'am.
Please give. Fresh orders after notice लिखित हुए
Fresh admission.
clearly लिखित हुए so that
Fine.
they will because they are right now they can't see the file.
Fine.
They appreciate. Yes. Just we are going after the memos. Any other memo? Yes, page wise करो तो call करो.
Page 1, 1 to 9. Page 2, 10 to 19.
My lord, item 16 permitted to withdraw, Lordship. Members of already memo filed, madam.
Okay.
Flag B is there.
Mr. P.K. Malik.
Yes, Lordship.
It is signed by you or Mr. Mahapatra?
I don't have instruction, Lordship. I have not seen.
Sign किए कुछ दी memo.
I have not seen, my lord. I have
Memo करना है. अच्छा ठीक है ठीक है. Other side किए अचंदी.
Yes, sir. Please, your lordship.
Mr. Behra.
Yes, sir. We can settle this matter of mutual divorce.
Cannot see, read that actually. Yes, Mr. Behra, disposed of?
Yes, sir. Your Honor.
Yes, yes. Next.
seen.
Item number 10, my lord.
10.
Yes.
Loss.
Yeah.
Yes, please.
Item number 10, though the opposite parties filed a IA number 3400.
So,
Don't
whenever you are
mention that.
mentioning a orders matter, where is the other side?
My lord,
That is there.
I am objecting this matter. Let them raise matter.
Okay. Don't mention, sir. Whenever your colleague is there, you talk to him.
Yes, man.
Yes, next.
But copy not available with me. That is
You know the sign 24 to 20.
Sir, sorry. चालू कर. ठीक अच्छी. You are there. So, but
Page 3, item 22, 28.
Item 22.
again.
As I'm saying,
22 post कर दियो तो. Will post it to a date. You are suggesting any date?
for example.
4 weeks पर कुछ. करो जल्दी. We commencing north evening. Yes, next.
Page 4,
Item number 29.
29 to
My learned
38.
friend Mr. Mishra is here. Here, my lord, this is a The husband has filed the case, okay, has filed a case there for divorce, and my lawyer friend being appearing for wife, he has filed an application that should be transferred from Koraput to Barampur. Now, my lord, the matter is, I think it can be settled. People worship and send the matter for mediation.
Transfer matter I cannot send for mediation.
No, entire everything can be settled.
I cannot. The problem is that I am not appellate court in MATA. The mediation is overburdened.
Yes.
So transfer petition you have to agree for either for trial at Barampur or trial at Koraput, or you file a 13B. But directing interfering in a 13B proceeding by a single judge is not what?
Anyhow, my lord,
Not possible.
yes, I follow.
13B is a division bench matter.
So my
13 is a division bench matter.
Yes, yes.
So if you are agreeing, let it be urgent, simply urgent. Yes, what do you say, sir? You settle it. Most welcome.
That
But the problem is, if you go to the mediator, what mediation the mediation order the court will pass, because you are seeking the matter for a trial at a particular place. That is the dispute.
now.
So mediator will pass the same. It can't go beyond the petition. Even perhaps single judge in judicial side also I may not go beyond the petition that way. But if you record suppose file affidavit that you do not want to prosecute the 13 petition. 13-1 or which petition or 9? What is filed by whom? Husband has filed what? 13-1.
Husband has filed the application for divorce there.
13-1 which provision ne file करछन?
13-1.
Cruelty desertion.
Yes.
So ଆପଣ agree କରୁଛନ୍ତି both of you can file 13B.
Now they will.
Whatever, or you are withdrawing the petition. But can he direct that settings that
Lordship will direct them to appear for mediation. It can
correct. Now, yes, I will direct them to appear, but the mediator will decide.
Mediator can decide whether dissolution or yes. I don't stop.
Maybe I seek your assistance and guidance also.
Okay.
So by putting a TRPC for mediation, what we are going to achieve?
I don't call this matter next week so that I will.
Posting କରିଦେବେ କେବେ ହେବ 29 କରିଦିଅ.
Interim order to continue.
No, I am not taking up of the matter. Whatever order is there will continue. Because it is simply no job. To save time, these matters where adjournment is sought for, no substantive order is passed unless required. Yes, next.
Okay.
Item 30.
Yes, Mr. Rao.
Item 30, I am for the opposite party. I want to file.
You want a date?
I want a date.
Good,
Objection.
Shashire. Quick. We commencing this week.
Problem.
Page 5, item 39, 40.
That's item 39. I appear for the opposite party number 2 and 3. I seek time to file.
That can be done at the stage of a mention in after notice matter. Inform the other side.
I have already informed today morning.
Okay, you take a date.
2 weeks to file counter.
We commencing not in question.
No, obliged.
Item 1,
Item 40. Item 40.
40.
सर एलियर जो ऑर्डर दिया है तो
Subramanian sir, kindly speak to the microphone.
सर आइटम 40 सर ଆମର जो इंटरिम जो दिया ହେଇଥିଲା ତାକୁ सर एक सर आइटम 40
ମାନେ ଆର୍ଗୁମେଣ୍ଟ କରିବେ
नहीं सर टाइम चाहूँ
ଠିକ ଅଛି ଡେଟ୍ କରିଦିଅ.
सर
Not will. We consent.
We commencing 9 March.
not much.
Yes.
Item 1,
May I please be for this?
So Samarendra Mahanti
Mine.
for the petitioner. Yes.
And the petitioner is challenging the proceeding judgment dated 3 February 24. Past the 125 proceeding, my lord. Maintenance has been awarded of
If you
50.
want issuance of notice, you deposit the amount
Yes,
Since, what is the date of order, sir?
date of judgment, my lord, in 13th to 24, my lord. In
So
here-
for 13 to 24 to December, you deposit. Then I will consider the matter whether I will issue notice.
My lord, only for the girl child I will pay, and
For
thereafter,
both.
no, thereafter, your lordship price, I have filed a miscase, my lord. Thereafter, that has not going to come. Thereafter, the 13B proceeding was finalized, my lord, and here is pending in.
This court is not appellate court, sir. There you have to go to the original court or ask the 13B court to take note of 125 order. I am not exercising the power of a magistrate or a family court. I cannot. If you are challenging on certain grounds,
Well,
I can confine my
I will
consideration.
pay, my lord, your
But if you want any modification, amount adjustment,
amount adjustment in the
so where?
in the
25 has been passed, 25 order has been passed.
125 order.
What you say? 25.
120.
Which act? 25 of?
In a divorce case, my lord, the amount has been adjusted for the wife, my lord, 20 lakhs permanent alimony.
Which
There-
section?
In the section 25.
Hold on. So there you want adjustment of 125 direction?
Yes, ma'am.
So,
I will deposit, my lord.
so suppose now you have paid 20 lakhs also.
That will be adjusted.
So 20 lakhs, have you called, I mean, brought to the notice of the court avoiding the permanent alimony, section 25 order? 13, that is 13(1) or 13B proceeding?
13(1).
13(1). So that amount, have you mentioned before the court to bring to the notice of the court that this is the amount awarded in 125?
Later on, after this proceeding, that has been decided, and the
When this permanent alimony was granted?
in 13/9/24, my lord.
So you should have brought to the notice of the court.
Yes, ma'am. I will deposit some amount.
When did you did not deposit also? Your problem is that you have not done anything. Have you deposited 20 lakhs?
No, my lord. That has a challenge here in Magta, my lord.
Then it cannot be. 125 cannot be stayed.
Yes, my lord. I will pay some amount. The execution.
Some amount. The exact amount, the decretal due, you have to pay. You are not, the husband doesn't become a Supreme Court or High Court by filing a 13/1 application. So that after the decree is obtained, he has sought for 13(1) decree. Did he take a plea that I will not pay anything before the Lord trial court?
No, he will pay.
Did he take a plea or kontana uttar kon dona? You are slow today, you are well. Usually apanko ete speed कम न था. Did he take a plea that I will not pay anything before the court? It's a matter of trial. Then how the appellate court will say that he will not pay anything? Anyway, we are not taking up the MATA matter. You are neither complying 125 order nor complying to 25 order, Hindu Marriage Act order. So you have whatever the petitioner husband is before this court challenging the judgment dated 3/2/2024 passed by the Lord Judge Family Court Jharsuguda in CMC number 13 of 2022. Stuff. By the said judgment, the Lord Family Judge allowed the application filed by the petitioner therein, wife, petition number 1 therein, wife in the marriage.
May I pray, my lord?
And the minor child, minor girl child born from the wedlock.
May I pray one thing?
Definitely you will pray, but I will have to pass orders also. May I pass order?
No, what I asini sir khali tiko.
Whatever. But should you are not required to interrupt the dictation of the order.
Obliged.
Are you required that? I don't think you required that. कौन कूट रहेला interruption? So the amount directed to the amount claimed in the petition was 50,000 per month. However, the court awarded 15,000 per month for the wife and 5,000 for the girl child. The petitioner has chosen, on being asked whether the petitioner has secured the amount directed to be paid, which is in the form of a money decree. The answer is no. The petitioner has not complied the said order for no apparent reason. The Lorette Court has considered the material in its considered the matter. Lorette Family Judge has considered the matter in its proper perspective by taking into account the material and evidence on record and past orders. It is further submitted by the Lorette Council for the petitioner that the petitioner husband had also filed petition under section 13(1) of the Hindu Marriage Act seeking dissolution of marriage solemnized between the petitioner and the OP number 1 on 26/6/2009, and the said petition has been allowed, granting decree of divorce, also directing payment of permanent alimony of rupees 20 lakhs. On being asked whether the direction to pay the permanent alimony after obtaining the decree of divorce has been complied with, the Lorette Council for the petitioner upon instruction submits that the said decree has also not been complied with by the petitioner. At this stage, the Lorette Council for the petitioner seeks adjournment to obtain instruction. List in the week commencing. କେତେ ଦିନ ଚାହୁଁଛନ୍ତି? 9/2/2026. Yes, next.
In the meantime, the execution proceeding may kindly be stayed, my lord, for depositing some amount.
Pay there. The best form of stopping execution is the strategy of not paying anything and depriving the legitimate decree of by judicial order will not work. Illegality cannot be given imprimatur. You take a stand there in the trial court that I will not pay. Let the court handle it. But after obtaining a decree, then you come and say that I will not pay. There is nothing on record, not to that's nothing is there. Copy of this order shall be forwarded to the Lorette Judge Family Court, Jharsuguda, to be tagged to the file of CMC number 13 of 2022, decided on 3/2/2024. Yes, next.
Come to
Passover Korthan.
item 3.
Type. Mr. S. CORAM for the petitioner. Yes.
The wife is the petitioner before your lordships and prays for a direction for transfer of the civil proceeding number 50 of 2025 from the Judge Family Court, Bhawanipatna, Kalahandi to Judge Family Court, Jaipur at Korapur.
Take notice, madam. Who is the petitioner before the
Husband is
Judge
the
Family Court?
Husband is the petitioner. Opposite party is the petitioner.
You have instructions to appear here. Please take your. The item 4(3) लिख ले. 3. Cause list देखो तू भूल भाल हो गया. The petitioner wife in the marriage is before this court. Seeking a direction for transfer of CP number 50 of 2025 pending before the Learned Judge Family Court, Jaipur. Learned Judge Family Court, Bhavani Patna at Kolahandi. Stop. Para. By the said, in the CP was filed by the husband in the marriage under section 27 into bracket B and into bracket small c, all small, 27B and C of Special Marriage Act, 1954, seeking divorce. Hard noted counsel for the petitioner. Issue notice along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within. Issue notice to the opposite party. Actually, yes. Within five working days. This chapter is, sir, liberty to mention. IA 496 of 2025. Issue notice as above, accept one set of process fee as well as postal requisites. Stop. In the interim, it is directed. ऊपर लिख लेने की fixing returnable date. which way जो लिख ले issue notice है file returnable date be fixed आज कितनी तारीख होती है कि
आज 22 तारीख
be fixed to 16/2/2026. In the interim, it is directed that if the petitioner moves the learned court, the learned judge, family judge Bhavani Patna, in the pending proceeding seeking adjournment, adjournment shall be granted beyond 27 February to 2026 as per the convenience of the court in season of the matter. List in the week commencing returnable date केवल देखिए छोड़ दो. List in the week commencing 23/2/2026.
Grateful.
Yes.
Deeply.
item
Yes,
4
Prisoner 6 for a direction transfer the CP number 239 of
Your
2025.
name, madam? A Panda.
S Mitra. Suman Mitra.
Mr. Suman Mitra for the petitioner. Yes, please.
6 a direction to transfer the CP 239 of 2025 and CP number 328 of 2025 from Family Court Jaspur to Family Court Bhadrak. CRP number 354.
What's the stage?
She stays at Jaspur.
Then how it will
My Lord, prisoner is staying at Bhadrak with her minor son.
but affidavit she has disclosed she stays at affidavit both addresses are given. Why at Bhadrak? Why she is staying at Bhadrak? With whom?
With her family, father.
Kindly mark the affidavit. You are not getting it. Always prepare the brief. Read it. Page 11 देखो तो.
At present, she is staying at Bhadrak.
अपन मते कौन कहले? What you said that she stays with her father. Look at the father's address.
Father is staying at Bhadrak.
Look at.
Daughter
Careful in reading also.
of Narayana, village Kuarpur.
Village Kuarpur, post PS Alakun, district Jajpur.
Yes. At present residing.
So who is residing at present? I have not written. Even the notices will be very difficult to issue also. You file that affidavit correctly, who is staying at who, where?
My husband's address is at Jashpur. Father's address is at
Bhadrak.
But who, why you have filed your father's residence at Jajpur, I do not know. By giving a speech, can you alter a affidavit? In affidavit, you have stated.
I'm presently residing at Padra.
You are not reading, sir. That's again the problem. How you will guide your? At least I am sure I am reading it. Narayan Raut, village Kuarpur, post Auri, PS Alakund, district Jajpur.
Before that, mentioned the wife.
इस तो पढ़ी में नहीं आओ कौन करे डॉक्टर लिखे तो वाइफ पढ़ी लेनी अपन
ना तब
अपन डॉक्टर नारायण रे सेंटेंस टा पढ़ूं तू
That's it.
अरे let us not pretend like that way
Before that, it's the wife of.
सेटा तो अलगा कथा से before that wife लिखले कि कौन लिखले मु कोई सेटा are we discussing that what address you have given of Narayan Raut again declaration टा देखो तो declaration same thing declaration में कौन लिखा है Narayan Raut village
Village Kuarpur. Oh no.
so how the court will infer that Narayan Raut to affidavit and declaration says that Narayan Raut village Kuarpur and you are saying it should be I will read it as Bhadrak Well, check करंतु you should avoid because other side will appear and say this and file proper affidavit. One page affidavit stating that where you are staying and what is if you are staying with your father because after reading this only I asked you.
Yes, my lord.
If you are saying that your father stays at Bhadrak or your parental home is at Bhadrak, you should have stated that. In the petition, have you stated anything?
I've just mentioned that kindly have a glance to page number 4, my lordship.
अरे paragraph कुहंतु कोटी लिखिचन straight away. Let us not meander through everything. If you have stated that you are this is the father's is at parental home is at maternal home parental home is at Bhadrak then इच्छे अपन लिखना
Parents only.
My lordship, page 6. She has no source of income to maintain herself and her child, for which she is residing with her parents at Bont. And she has to go along with her minor son to attend the court of Jajpur, which is 50 kilometers.
is submitted by the learned counsel for the petitioner that though in the affidavit as well as the declaration, it has been stated, quote, daughter of Narayan Raut, village Kuarpur, post Auri, PS Alakud, district Jashpur. पूरा देखी लिखी करी तो भूल हवन ना 8% residing at Baligadia, post Vegana, PS Born, district Bhadrak, portends the petitioner stays with her parents. Who address कौन?
Bont, my lord.
at Baligadia. At village Baligadia. Repeat करते हैं. Post Begona, PS Bond, district Bhadrak. Para. The petitioner wife in the marriage seeks transfer of the
transfer of the CP number, my lordship, 239 of 2025 and CP number 328 of 2025.
ସେଟା ଲେଖିବେ ନା ଏମିତି କଣ 3 series କଣ ଲେଖୁଛନ୍ତି? What sort of a prayer we are making? You have written petitioners presented by opposite party number 3 annexed 3 series. The judge will find out the number. कौन लिख ले? CP number 239 of 2025. 20 before the learned judge, family court, Jajpur. As well as CP number 328 of 2025. Filed under section 6 of Hindu Guardianship and Minority Act. Also pending at the family before the learned judge, family court, Jajpur. To the court of learned judge, Bhadrak. La. High learned counsel for the petitioner issue notice along with this order to the opposite party by speed post with registration and proof of delivery. List after SR liberty to mention. The returnable date shall be fixed. जोड़ा देइथिल सेटा रिपीट कर देते सबुडा से रिपीट कर दो whatever आपण 16 डाकिली कि 15 डाकिली जे आपण लिखिथिबे आपण आगुर कोन लिखछन आपण 16 काई होचन आइए 4979 of prayer that annex of 3 series. Annex of 3 series can never be, that is a style of administrative order. So still you have to write the annex, the order dated so and so, annex of 3 shall not be quashed. But that you are importing to a, petition. Anyway. Yes.
Item 5.
Mr. Naik for the petitioner. Opposite party blank. Yes.
Paper or transfer CP number CP 224 from Barampur to Bhubaneswar Financial Services.
Who has filed at Barampur? Who has filed at Bhubaneswar?
Husband filed at Barampur, my lord. Wife filed at Bhubaneswar.
What is the petition?
My petition is a divorce. He is filed 9 of Consular rights file at Barampur.
And what is the ground of seeking divorce?
Distance, my lord. I am the working lady and is a newborn child with 2 years child is with me.
So the jurisprudence has developed. Whenever a working lady is placed with a child, it has to divorce to be granted.
No, पढ़ुनी तो से मन मिलूनी क्वालिटी आसुची सब आसुची तो से रही पारलानी बोले पड़े आस
क्वालिटी कहबे ना 13-1 ग्राउंड अपन डिस्टेंस आलेनी 13-1 अमेंड नहीं पर्यंत जहां ग्राउंड थिला 13 रे अछि हमरो आवर डिस्कशन शुड बी हैव सम कॉन्टेक्चुअल मीनिंग. The petitioner wife is before this court seeking transfer of CP number 460 of 2024, pending before the Learned Judge Family Court, Barampur. That says the said CP has been filed by the opposite party husband in the marriage under Section 9 of the Hindu Marriage Act, seeking restitution of conjugal rights. But it is submitted that CP number 8 to 9 of 2025 has been filed before the Learned Judge Family Court Bhubaneswar by the present petitioner wife in the marriage under section 13 into bracket 1 into bracket I-A of Hindu Marriage Act. Issue notice along with this order because it's for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days. 5 working days. List after SR, liberty to mention. IA number 1 of 2026. The petitioner se order ta repeat kale to eta kar paribeni hala. The proceeding pending before the filed by the petitioner pending before the Learned Judge Family Court Bhubaneswar CP number 8 to 9 of 2025 shall also be adjourned beyond that state. The petitioner shall produce the copy of this order before the Learned Judge Family Court Bhubaneswar on the next date. The next date of posting of the said matter. Yes, next.
Same as item number 4. I have mentioned.
Item 6.
I have mentioned in paragraph 9, page 6. I am residing at Uttarpur, Jaspur. Petition is the wife challenging the second transfer, section 9 of the petition filed by the husband at Bhadrak.
Mr. Somnath Nanda for the same parties you are saying?
No. So defect as a say defect of originality.
Defect no, you have to take care of your statements made in the petition. Your submission is just opposite to the what you have written. Narayan Raut, village so and so, Jaspur. You want the court to read it as Narayan Raut staying at Bhadra. How can it be?
My permanent address is at husband address.
Sir, can the affidavit be supplemented by a speech regarding what is the contents of the affidavit? One has to read the affidavit. Either you read or I read, but it makes no difference.
Para 9 I have mentioned. I have filed a criminal proceeding. Proceeding I file korchu, maintenance file korchu eti. Jaspur.
ଆପଣ ଯୋଉଟା ଫାଇଲ କରିଛନ୍ତି ସେଇଟାକୁ ଟ୍ରାନ୍ସଫର କରିବାକୁ ଚାହୁଁଛନ୍ତି?
No. Section 9 filed by the husband is transferred from Bhadrak to Jaspur.
ଆପଣ 13 ଫାଇଲ କରିଛନ୍ତି ସେଟା ତ ପଚରା ହେଉଛି। ତାହେଲେ ଆପଣ 9 କୁ କାହିଁ ରେଜିଷ୍ଟ କରୁଛନ୍ତି? ଭଦ୍ରକରେ ହଉ କି ଯାଜପୁରରେ ହଉ କି କଟକରେ ହଉ?
He has made allegation against me that for some then seeking conjugal rights. He has made frivolous allegation against me.
Sir, did I ask you a wrong question?
No.
I asked you that if ଆପଣ ରହିବାକୁ ଚାହୁଁନାହାନ୍ତି, suppose you say that no, I have not, I do not. Then why you are registering section 9?
Section 9, there is a chance of murder. There is a chance of life.
Then why you are not filing 13?
Sometimes, after sometimes, his mind change. It may mind change as well.
Mind change from what to what?
And the young with the Samparka Ball asla.
From murder to injury.
Realize if both parties will realize that they will.
You make an extreme statement that your husband wants to murder you. Then you expect that the husband will change his mind and say that I will not commit murder or what? Mr. Nanda, you should advise your clients. What sort of activities they are indulging in. The person, even if not your husband, if you allege that he wants to murder you without any basis, he will be aggrieved. Nothing, sir. This litigation, the entire scheme has failed because of this. People do. This is an example only. People have a paranoia that somebody will kill him or her, and still you expect that he will adjust with you. You are thinking the extreme about the person. Even if he is not your husband, anyone in this world, can he or she will accept this kind of paranoia?
I think
ଆପଣ କିନ୍ତୁ ଠିକ ଲେଖିଛନ୍ତି କ୍ୟାର ପୂର୍ଣ୍ଣଚନ୍ଦ୍ର ବେହେରା ଭିଲେଜ ଉତ୍ତରକୂଳ PS ଅଲାକୁନ ଡିଷ୍ଟ୍ରିକ୍ଟ ଯାଜପୁର
ତା 31 ଫାଇଲ ହେବା କାରଣ ହଉଛି
ଆପଣ page 9 ରେ that should be the correct statement. ଆପଣ ଯଦି ଲେଖିଥାନ୍ତେ without anything village ଆଉ post office so obviously the sentence ଟା କଣ ଜଣେ ପଢି ପାରିବ କଣ ଲେଖିବେ but you said that ସେଇ ଭଳିଆ ଲେଖା ହେଇଛି ବୋଲି it is written correctly. So and so Behera, is it about so and so here at present care of Purnachandra Behera, but you have not written whether daughter or whatever, but you have written it care of so and so village so and so.
Yes.
Yes. The petitioner wife before this court seeks transfer of the CP number 315 of 2025 pending before the learned judge family court Bhadrak to the court of learned judge family court Jajpur. What is the distance between the courts at Jajpur and Bhadrak?
Through via Panikul 66 kilometers I have mentioned.
And what about the other road, internal road?
Other 50 kilometers. But there is no vehicle communication.
Have you traveled that?
I am relocated to that.
Which place?
Town.
Sorry?
Town.
That's the problem. You are not thinking beyond the town. After those bridges have been the distance to Bhadrak has reduced by around 10 kilometers.
Bus communication.
Whatever, upon bus that's a different thing. The distance has reduced.
Maybe. But
even I have seen this Kuakhia bridge was not there. You have to go to Panikoli, then
yes,
that bridge which was washed away after super cyclone.
Rodia bridge.
So distance is also, I think, I'm not very sure whether we are saying the, anyway.
Yes.
Only 6 transfer. The said CP stops. The said CP was filed by the husband, opposite party husband in the marriage, seeking restitution of conjugal rights under Section 9 of the Hindu Marriage Act. Bara, hard lauded counsel for the petitioner issue notice along with this order. So जो डेट गुड़ाक अच्छी तो 2 days लेके ऐड कर दो तो केते डेट अच्छी पढ़ू ना रिटर्नेबल के बे लिस्ट के बे हबो सब तो 2 days लेके ऐड कर देबे नले आपण केते सेम नले एटा भी से एका डेट कर दियो रिटर्नेबल डेट जहा सब समान रहे. You seek adjournment before that court? Yes. I am not granting stay.
Yes.
Because you see, you are seeking, the husband is seeking restitution, you are stalling of the proceeding. And when I ask you that why you are not filing 13, you say that he will change his mind and you will change his mind also. Anyway, let us leave it there. I have dictated the order.
2 years also there.
2 years कौन दरकार?
To divorce point of ତାଙ୍କର
13 भी फाइल करचंदी
मैं फाइल कर
करि तो नांती कौन 2 years दरकार कहउचंती. Yes.
Seven.
May I please, your lordship? My lord, in this the petitioner.
You are Miss South.
No, my lord. SS Naik, my lord.
Miss SS Naik for the petitioner. Yes.
My lord. My lord, in this case, the petitioner is seeking to transfer the CP number 40/2025 from the family judge Anugul to the learned family court Bhadrak.
Who had filed the CP?
My lord, the opposite party is husband. He filed the CP in the family court Anugul.
Yes.
And my lord, and 2 other cases, the DV number 239 of 2025.
For what? CP number at Anugul filed seeking what? What direction?
Sir, for decree for divorce under 13 1 and A.
The hard learned counsel for the petitioners. The petitioner wife in the marriage is before this court seeking direction for transfer of the CP number 40 of 2025, pending before the Lord Judge Family Court, Hon'Ble. Hon'Ble stuff. The said petition has been filed by the opposite party husband in the marriage, seeking dissolution of the marriage between the parties solemnized on 7 July 2022. Issue notice along with this order. Requisites for issuance of notice of para, requisites for issuance of notice by speed post with registration and proof of delivery be filed within 5 working days. Returnable date be fixed to, Aroda kete fix kartile? 16. Returnable date be fixed to 19 January, 20 January, 20 February hobo. Ami aji 21 tarikh achu. Be fixed to 18 February 2026. The matter shall be listed in the week commencing 23 February 2026.
My lord,
Then
we filed and
18 of 2026. Hard learned counsel for the petitioner. She reiterates her submissions as recorded above. He is here. Hard learned counsel for the petitioner issue notice as above. Accept one set of process fee as well as postal requisites. Returnable date be fixed to. जो डेट का कॉल करते हैं जोड़ा पर लिख ले हाँ in February week commencing case लिख ले in the interim it is directed if the petitioner files 6 adjournment not files 6 adjournment before the learned judge family court कोठे जी भद्रक ना जाजपुर
my lord,
अनुगुल
to Bhadrak, my lord.
अनुगुल in CP number 80. The said matter shall be adjourned beyond March. The returnable date listing करो विचरे सोचो 23 next date हबो next week पर next week तक पे हबो beyond 2nd March 2026 as per the convenience of the learned court in season of the matter. Liberty to mention, list after this, liberty to mention. Yes.
My lord, certified copy may be granted in the court.
Certified copy, the urgent certified copy as for.
Bless my lord.
Yes, please.
Item A. The petitioner is the husband before a lordship seeking a direction to the judge family court of Bhubaneswar for early disposal of the
You are Riyaj or Irfan?
Riyaj.
Mr. Mohammed Riyaj for the petitioner. Yes, what do you want, sir?
I is seeking a direction of judge family court for early disposal of the divorce proceeding.
Have you filed affidavit that this is the only divorce proceeding pending?
Yes.
So that
prior to that, restitution conjugal words.
Before the particular court, this is the only case pending.
That
I will not pass discriminate other litigants who cannot afford to engage you and get a luxury of approaching High Court for early disposal.
No, because why are coming before lordship? In 2015, I have filed a restitution conjugal rights.
No, you are not getting it, sir.
I understand.
You might have filed the petition in 2005. That will not guide the court to discriminate the other litigants.
Then because kindly have turned the order sheet in 15 to 2025, I filed an evidence affidavit. Till then to till now, the opposite party wife was filed an application on one and another.
Have you referred to CPC where the opposite party doesn't appear, then the petitioner appears? Have you referred to CPC?
But that learned court will not waited. The
will not wait, sir. The lawyers actually they dictate the entire proceeding. It's so easy to tell that. And whenever, because you see in some matters you are also taking time, adjournment. That is how we are. I mean, I don't find any exception to that. So we accommodate our brothers.
My only predicament is that due to pendency of the
file that petition.
I have superannuation from my service. No, neither the wife was.
So you are not the only person who was superannuated involved in the matrimonial proceeding.
That also, if
After superannuation, at the age of 66 and 67, they are filing application. So that is not a ground. You must bolster my order. If I observe these things,
yes,
my order becomes laughable. First of all, I am discriminating the person who has not come to court. He has also superannuated. He filed a petition in 2005. That is the problem. It is an enormous problem. It is in Bhubaneswar. Bhubaneswar, even after 3 courts, the situation is really lot of problem. Now this even mediation and counseling has become overburdened. Because cause of action, because the marriage is happening at Bhubaneswar being a metropolitan city, almost it's a big city, corporate. So many petitions are filed, lawyers are available. And we direct them that don't jump the queue and don't treat the cases with any priority. Do justice to all. And in judicial side, I will direct that don't do justice. You take up this particular matter out of turn. If you are filing an application, order is passed, you are aggrieved, you can very well bring to the notice of the court. So that order I will pass that they will not discriminate, no unnecessary adjournment, and you will move the authority.
No, evidence has already been filed.
Whatever, sir, I cannot become the trial court.
My difficulty I expressed.
In hundreds of cases, evidence have been filed and the matter is pending. That is how I have been categorically asked you. That if this is the only case, then you state it on oath, I will direct that.
My difficulty is that due to pendency of...
Your difficulty cannot lead to illegal order by the High Court.
That I made a prayer before Lord.
No, prayer has to be made to be legally sustainable. How can I direct that you choose this particular petitioner who has filed the petition 2005 or 15 years filed? I cannot. That is not a basis to discriminate between litigants.
Because more than decade of years I am roaming inside the judicial juncture, Lordship. That is my...
Can I observe that? When people have been running around from trial court to Supreme Court for 20 years in matrimonial disputes. Have you read this yesterday's Justice Bindal's, Honorable Justice Bindal's judgment? They stayed together for 65 days. Filed 42 cases against each other. They have the observation by the Honorable Court is that they have clogged the system. And now, even then also, Supreme Court has exercised 142 to grant them divorce. Still, they have not agreed. They could not file a 13B. So in that kind of scenario, how can I discriminate a litigant, the person who has retired and he is not having anything, but he doesn't come to you to file a writ application for expeditious disposal? And difficulty in appearance also, you file your ICT application that I will have wherever you are staying. Because there can be two difficulties. They're staying at a remote location or a different location even. Not even remote location, different location.
It belongs to Barampur.
So you file that application. Utilize the technology. But how to prioritize the person who is staying in Barampur, his case should be prioritized at Bhubaneswar. Please appreciate that also. Those kind of orders cannot be. And check the Supreme Court decision on this. There are direct decisions. That's the court should not expedite matters at the cost of other litigation and litigants. The petitioner, husband in the marriage, after filing CP number 372 of 2024, before the learned judge, pending before the learned judge family court, has approached this court for expeditious disposal of the said CP. On being asked whether any other litigation is pending prior to the said CP of 2024, where evidence has been adduced by the petitioner, it is fairly submitted by the learned counsel for the petitioner. That is not the case. However, the petitioner has some difficulty due to pendency of the matter. Para. In considered view of this court, a particular litigation cannot be expedited. A decision a particular decision cannot be expedited when several when thousands of the similar CPs are pending before the Learned Court, Learned Judge Family Court, Bhubaneswar. And many other litigants are facing the same situation due to pendency. Stop. However, if the petitioner is so advised, they'll take steps according to law, as it is alleged that the opposite party is not cooperating in taking up the matter. The petitioner shall move the court, if required, for utilization of the ICT facility. If any such application is made, the same shall be dealt with in accordance with law. The petition stands disposed of.
Okay.
Item 9, battery.
Mr. Vivekananda Jena for the petitioner. Yes, Mr. Jena.
So the petitioner, your lordship, is the wife challenging the order whereby her application under Order 9, Rule 13 for recalling the ex parte order, ex parte divorce order, that was rejected, your lordship.
But it is MATA. Single judge rahi paribani.
No, এটা mu challenge করুনি divorce টাକୁ mu challenge করছি the order rejecting my application under Order 9, Rule 13.
Correct. It's a division bench matter. Order 9, Rule 13 in a CP under Section 13.
Again.
This is a division bench matter. Writ application is not maintainable. You have the choice of challenging both. Grant of decree.
Again.
Order 9, Rule 13.
Again.
Now suppose I accept your contention is accepted.
Again.
Then who is the appellate court in judgment granting decree of divorce?
Judge Family Court.
No. Which is the appellate court?
Division. Division.
It is all. It is apparently I lack jurisdiction.
Again.
But dekhundu eta. So Order 9, Rule 13 challenge is also again before the division bench. Same, just like 13, because along with Order 9, Rule 13, you can challenge the final decree also. Yes. The petitioner wife is before this court challenging in the writ the petitioner wife in the marriage, by filing the writ application, challenges the order passed by the Learned Judge Family Court, Balasur, rejecting the IA 44 of 2020, filed by the petitioner wife under Order 9, Rule 13 of CPC for recall of
setting
ex parte, for setting aside of ex parte decree. Judgment and decree dated TAS. In considered opinion of this court, for challenging a ex parte decree in before this court, MATA is the proper application, which is not in the determination of a single judge, but in the determination of a division bench.
Your lordship may grant liberty.
The petitioner has the liberty. No, I am not disposing it. The petitioner has the liberty to obtain instruction and take appropriate steps.
By converting
the petitioner, the Learned Counsel for the petitioner seeks accommodation to obtain instruction and take appropriate steps. When you file the MATA also, then also pendency, the delay, you can cite this, that it was filed. But this cannot be converted to a MATA because I think the format has to change also. For a writ petition format record, they change. Yes. How much time?
2 weeks.
Accordingly, the other matters shall be listed in the week commencing 9/2/2026. The petitioner has the liberty to take appropriate steps for as available under law. Any adjournments, you will give you.
Yes, my lord. I already informed in the item number 10, my lord. I informed Mr. Bose that the IA filed by them is the copy of that not available. with us.
The opposite party. We have to solve the copy in 24 to 2025. Subcopy.
And file the memo.
Okay, sir.
Receipt memo achi.
Yes, my lord.
So it has to be a mediation. There's a mediation. Mediator. Division mediation होच. ये जो काली वाले dispute है लास्ट से पहले मोटू नहीं वाले वाली. The esteemed counsel says that after I see handed over the copy, it was taken away. So vacate the interim order. You don't join issues here. अपना soft copy नहीं पढ़िए sir.
Yes.
Now the problem
I will collect that. I will collect.
in a particular scope, if I observe that copy served, not served, it becomes out of context also.
Yes.
Adjournment से नहीं होता. Mr. Sahoo?
Matter may be called on next week.
My lord, they also received the copy and this is the receipt signature.
नहीं अपन पास पहले से सुनी ला अपन why you are embarrassing him further. अपन से किसी हॉल मारले से अपन सुनी लेनी चाहिए receipt अच्छी बोली. So केबे अपन agree for a date कही दियो तो सेबे आसीबो we commencing.
Who date रखने बोले?
The item 10 देखो तो Mr. J Barik.
Yes, my lord.
So J Barik for the petitioner, Mr. Sahoo. So Mr.
JK Padi, my power is.
JK?
Jayant Kumar Padi.
Mr. JK Padi for power name.
No,
on behalf of AP Bose for the opposite party. Lord Counsel for the petitioner 6 and extra copy of the IA.
Yes, my lord.
IA. The Lord Counsel for the opposite party submits that he has already served the copy. Stuff. The learned counsel for the petitioner has liberty to obtain soft copy from the office of the from the registry of this court.
Yes.
List in the week commencing. Taste Louis.
Maybe only
Aguru.
Because there is an entry order there. That's why they
stay.
Past week of.
Last week so good है लेकिन अपन तो last week पहुंचे हैं almost.
Past week.
The week commencing 16 Louis.
So interim order to continue.
Interim order as passed earlier shall continue till the next date of hearing. Sir, whatever. So any date you adjournment, please. Sites are there. Please don't difficult.
I filed a so cause affidavit, madam.
Yes, sir. Whatever, sir. But a judicial order has to be passed. I will come back. If you want adjournment, if you agree, you take a date.
Since so called is just filed, I am just receiving the same.
Whatever you play adjourn, sir. If you wish to come back, I'll take it up. If you have any difficulty, you are leaving the court now or going to other court, no problem. Today date they कहबे अपन बुझी देबे आगे अब लेन some other day you were
Mine.
yes. So why you should have? I say that you take your answerments. You should not have waited actually. Because I'm trying to save that time in 32 टा को date कर दिया तो
16 2.
Commencing 16 2 से कोचन. Yes.
Item 27. I for the petitioner, my lord.
Yes.
I pray for a short adjournment, my lord. I have informed to other party.
Arjun.
16 2.
Oh, bless you.
Yes. और पूरा सेंटेंस है कोन आंती अपन 16 2 कोचंदी.
कोई काम से
हां सेमटी का मुंह करे कहि गई ता आपनकर पालिया. So जने लेकर खाता लिख दो 16 2. So it better list होबे न कंफ्यूजन ना आरंभ होला ता सीट. Yes, next please.
Item to
non-actors for the petitioner. Though the matter is called twice over. Once when it reads, and again, after resumption of the proceeding post recess. To grant further opportunity, list in the week commencing.
9
2 26.
Item 11.
So why you said
Yes, my lord, in this
he is
case,
seeking time? Yes,
they have just now served a copy
No
of the
difficulty.
Sloka's affidavit.
You take your time after instruction.
Your lordship, after 2
Mr.
weeks,
Santosh Kumar Swai for the petitioner. Mr. P.K. Mahanti ASC for the opposite party. The Lord ASC submits that he has upon kebe file karle?
Today.
He is filing the SOCOS on behalf of the opposite party today. The SOCOS shall be taken on record, scanned copy be updated. The copy of the SOCOS has been served on the Learned Counsel for the petitioner in the court. He submits that he shall obtain instruction. Stop. Accordingly, the matter shall be listed in the week commencing.
Not in.
Not in Kudiye.
Yes, sir. Milord, on the previous, since the opposite party one has already filed a SOCOS affidavit, on the previous occasion, direction was made for filing of recusancy for service of notice on OP for filing SOCOS. Since they have already filed SOCOS notice,
okay, that will be compliant. The office note regarding filing of requisites for issuance of notice to OP shall be ignored in view of the OP having appeared and filed SOCOS.
Obliged.
Item 2A.
So Jagannath Bhuya for the petitioner. Yes, Mr. Bhuya.
There is a 79 days delay in preparing the revision, Your Lordship. For which
what is sought? What is the revision sought about, sir?
Revision, Your Lordship, challenging the order of the maintenance under Section 125 towards the
grounds of challenge, sir?
Grounds of challenge, Your Lordship. My main ground is that the OP number 2, the son, is not my son. That is, and the OP number 1 is my second wife. So OP number.
Look at the provision.
Yes, I bow down to that, Your Lordship.
So this logging of the courts with these kind of petitions actually, have you sought for divorce?
No.
Then
not yet. So I have to.
Legal presumption. There is a legal presumption.
Yes, I bow down to that.
Regarding this legitimacy of the child, it cannot be gone into
in a 125
petition.
Yes.
Second, the section makes it clear upon production of such upon proof of such negligence. That much. Nothing else. Nothing else.
Sure.
Even it doesn't grant an opportunity for the other side to, and 125(3), if it is not compliant,
then
arrest and detention. 2023 order.
Yes, it's a 8/11/2023. Your Lordship.
If you want issuance of notice, you comply the part when it was directed.
Yes, sure.
You obtain that instruction. I will pass that.
I will obtain that.
Yes, unless you comply, I am not
grateful, Your Lordship.
It's a big, huge challenge for the entire system to handle it.
Yes.
Where we are also the part of system. You, me, and the litigants. Hard learned counsel for the petitioner. The petitioner husband in the marriage, you take your seat.
Yes,
take your seat. Petitioner husband in the marriage has approached this court challenging the judgment dated 8/11/2023, passed by the learned judge, Family Court, Keonjhar, in CRL.P.NO.30 of 2018. CRLP and all capitals. Stop. By the said judgment, the petition filed by the petition number 1, the opposite party in the present application, OP number 1 in the present application, and the minor child of aged about 3 years. Minor child, then aged about 3 years. Under section 125 of the CRPC, into bracket, since repealed, has been allowed. All right. On being asked whether the petitioner, for challenging the said judgment and decree, which is a sum payable to the opposite parties, has been secured, or the petitioner has secured one. Sentence about the bhul hai. आरंभ कौन करेगा? Has secured so and so for challenging the same. তাহলে আপনি যাহা লিখে মতো করেকশন করবেন। For challenging ঠিক ছিল। Has secured. It is some the learned counsel for the petitioner submits that he shall obtain instruction. How much time, Mr.?
2 weeks time.
Where?
2 weeks. 2 weeks.
Accordingly, the matter shall be listed in the week commencing.
North in.
North in 2026.
Grateful yours. Great.
Line add kori challenge likhni. The petition has been filed after a reported delay of
79 days.
79 days. Stop. Yes.
Great.
M.K. Chan for the petitioner.
Here is a case where the learned court has awarded interim maintenance of 5,000 to the opposite party. And the ground of challenge which I have urged before this honorable court is that the opposite party, the wife, suppressing her status to be the married wife of somebody else, has filed the application. And when I put forth this particular point with the honorable court, she herself has exhibited 2 documents. That is also before this honorable court. Madam, may kindly have a glance to it. That is annexed 1 and 2. The Nikah register, the copy of the Nikah register, as well as the Talak Nikah register, Talak Nama.
You deposit some amount. You are disputing you are not disputing the marriage. Saying that the marriage is irregular or illegal because earlier marriage.
Well, my humble submission, when she was the wife of the particular person, till particular period, and she has manipulated all such things, and to my
no, has she not obtained khula?
It's the patta annexure 3 management.
Because like talak also,
yes,
she can obtain khula also.
Like khula bhi hai nahi. She has filed a document annexure 2. That is a talak nama. But it has been executed before the concerned panchayat. It is also not permissible. But may kindly have a glance to the exact lining. Page 14.
Do they read Mullah in Muslim law or
uttering the word also meets the purpose. But my humble submission is required to be sent to the concerned persons for the information. Otherwise, it will not be materialized.
But the petitioner doesn't dispute his marriage.
His marriage again, the moment maintenance has been filed by the wife.
Because their personal law is very liberal. Their personal law, after that period, she is ready to marry again.
I do consider, my humble submission, when she was the wife, she is continuing the status of the wife of that other person. The subsequent marriage is not permissible. Of course, it can be materialized with the permission of the past husband or the person that is married.
Yes. So that is how I say you.
No, nothing.
Their personal law is liberal for the lady also.
For the lady means not to give liberal to all aspect regarding.
No, not exactly the interpretation that multiple marriage.
I with all respect, I'm not.
Even if a lady wants khula or talak, and she has undergone.
She can. I do consider. I do consider. But side by side.
You deposit some amount to obtain instruction. Deposit some amount. Since when? Order.
Aye. My lord, the order is 9/2/2024. Yes, obliged for that, my lord. No, yes, bar members have also sent it through WhatsApp. 3-4 days, 2 or 3 days, it has been notified, and everybody has said just to communicate because of my preoccupation. I was not in a position. No, it has been communicated. And the bar members has also intimated to express their before this. No, it's with all respect, it was a continuing effort for a longer period.
The system has to take credit.
Yes, obvious.
The petitioner husband in the marriage is before this court. By how much time you can obtain that instruction? Or you have any instruction because there is difficulty in matrimonial matters. Clients do not listen.
Sir, my lord is right.
The petitioner husband is before this court challenging the judgment dated 9/2/2024 passed by the Lord Judge Family Court Khurda in CR criminal petition number 288 of 2019. By the said judgment,
Maybe delay টা আছে যদি delay is there.
and observe everything. Last level of delay so that next time if it
Sorry.
Ironically, I had not had counsel for the petitioner. By the said judgment, the petition filed by the opposite party wife seeking maintenance, invoking the provision
25.
that is section S.125 of CRPC into brackets since repealed was allowed. They submitted that prior to the marriage of the opposite party with the petitioner, she was already married and the said aspect would have a bearing on grant of so it was stated before the Lord Court that the marriage of the opposite party with the petitioner was after she had after the first marriage had ended up in talak. ENAQ. The appeal has been filed after a reported delay of 27. I'm being asked the learned counsel for the petitioner submits that he has no instruction whether any amount was deposited to secure the decree, secure the amount of maintenance due to be paid. Stop. Accordingly, the matter is how much time? 2 weeks. 2 weeks. Accordingly, the matter is urgent to be taken up in the week commencing 9/2/2024. None appears for the petitioner when the matter is called. The notices as directed by the coordinate bench by order dated 2011. By 17/9/2025 could not be issued as reported by the registry due to non-filing of postal and other requisites. Stop. To grant further opportunity to the petitioner, list in the week commencing 2/2/2024. Yes, next. 15. Mr. 15. Sahoo for the petitioner.
Here, my lord, this petition is filed for transfer.
Other side has appeared. Notices were issued, Mr. Sahoo, earlier.
Yes, my lord. Notice already been served, my lord.
Opposite party none?
Opposite party Kalinga Kesari Raut.
No, though they have appeared. None appears for the opposite party when the matter is called. To grant further opportunity, list in the week commencing 9/2/2026.
Interim order, my
Interim
lord.
order dated.
No interim order. has
Acha,
been-
interim order is not there. Okay. Any difficulty you had find the
Yes, my lord.
interim order?
It is 4-5 times has been adjourned, my lord.
No, you had filed interim order seeking what? Prayer, interim prayer is for what?
Still further proceeding, my lord.
The allotted counsel for the petitioner reiterates his prayer for grant of interim order in I 113 of 2025. Since notice has been sufficient, the allotted counsel for the opposite party has appeared and no one is appearing to object the prayer of interim. No one is appearing to object the interim prayer. Stop. Comma, stop, no comma. As an interim measure, it is directed the further proceeding in CP number 396 of 2024, pending in Learned Family, pending Family Court, Jajpur. Shall remain, shall be adjourned till. आज केबे को डेट करछन आपण 9/2 commencing 9/2 adjourned till the week commencing 16/2/2026. The registry shall intimate the copy of this order to the learned counsel is on record for the opposite party. Yes. से बोधे कथबार्ता है कि सेटा करछन आपण माने लडुचंती बट दे हैव सेड से केसटा स्टे हेले तो किछ असुविधा नै एटा की सेठी केस फाइल की करछंती
सेठी हस्बैंड करछन
आ से वाइफ कहिथि कोन केस कोन करछ स्टे हेले हां स्टे हे जाऊ सरला तापर बट आपण माने एठी फाइल करी वकालतनामा फाइल करी कि पछते काई केस करछ ना मु किछ केस करनी
सेक्शन 9
तापर सेक्शन 9 ता माने तो नाउ सेक्शन 9 हैज बीन स्टे कोन होबो ताले
ये
सेक्शन 9 स्टे केन करछन सीधा आसुनांती ठीक आपण पिटिशन को रेस्पोंड करिया
मोर ट्रांसफर
फाइटिंग बोली 13
नहीं से जणा
भलरे खुशी रे अछन और ठीक अछि आपण तो इंटरव्यू ऑर्डर हेची देखंत बट apparently there is nothing no future of this TRPC. Yes, it will just add to the pendency. Yes, next
16
हाँ Mr. PK Malik petitioner मेमोटा आपण एथरे जोडा अछि सीडा Mr. PK Malik for the petitioner, Mr. Subhash Chandra Behera. Subhash Chandra Behera for the opposite party. The matter is mentioned to the list is called. The learned counsel for the petitioner submits that the petitioner has filed, memo has been filed. Memo has been filed on behalf of the petitioner for withdrawal of the TRPC. Stuff. The learned counsel for the opposite party present in VC at Sambalpur. Present in virtual court, High Court of Orissa at Sambalpur, submits that the parties have reconciled their differences and the matter may be disposed of. Stop. According to the matter, stands disposed of. तो मेमोटा लिखले नहीं डेट लिखो मेमो dated 18/12/2025 Dakini sentence. A memo dated 18/12/2025 has been filed by the petitioner for withdrawal, which is on record. Yes, next please.
17
May I please, Your Lordship? My lord,
What asked for the
yes, ma'am.
petitioner?
My lord, here is the case. The notice was issued because only on the purpose that it will come and through mediation it can be resolved. But what I found out, the address which had been given in the trial court, on the basis of which I took notice, once it is returned unserved because the address is not found.
Again, what I pray before also here, order and rule line application ought to have been filed instead of filing writ petition before the report. If you also give me liberty, I'll file an application. That is also application for delay condonation. Because
kindly file a memo. Kagasta de diyo.
The withdrawal.
Whatever you said, you will just write it and keep it on record.
Okay.
Order and rule line upon jab file karibe.
Only anxiety is here. 99 application has to be filed there, not here.
I understand.
And that too, I have
a period of prosecuting bona fide litigation here will be obviously calculated.
That will be better. Again, I will take service notice, then she will not appear. It will only take time for this. That is why only the prayer.
You write order and rule line exactly, but you may say that appropriate remedy available under law. That much.
No, what anxiety withdrawal client will say we have withdrawn. That is why only
you say you write that the petitioner wants to pursue the litigation, pursue the matter by invoking the appropriate provision of law.
This merit of the case.
And the present application is not pressed that much. Or whatever, because the language there you cannot improve the language much. I have tried to improve it.
That is the only anxiety. Lawyers engage with supply. My lord can be disposed with the liberty.
Hard on counsel for the petitioner. The notices issued by the coordinate bench by order dated 18/8/2025 has been returned answered. The application, the writ petition, in the writ petition, the petitioner husband challenges the order passed by the learned judge, Family Court, Bhubaneswar. Dated 20/12/2023.
Yes, ma'am.
In CP number 658 of 2011. The state order, by the state order, the learned judge, Family Court observed thus. Quote kar den, hai page 14 judge. In considered opinion of this court, the petitioner has a remedy available under the Code of Civil Procedure. Order 9, Rule 9, before the learned judge, Family Court. Stop. Accordingly, it is observed if the petitioner moves the court within a period of 4 weeks,
yes,
seeking appropriate remedy under the provisions of law as would be applicable, the learned court shall deal with the same in accordance with law after giving due opportunity to all the parties. The petition stands disposed of. No, you only helped it. Okay. because in fact, you have been hearing me. I find in matrimonial causes, TRPC has only added to the burden.
Yes, yes.
If you try to understand what is happening, you can never.
Yes.
Difficult to do so.
That is happening. It's a fact.
Mr. Sahoo, the petition is pending there.
Yes.
TRPC, they are after appearance, they are not responding. In some matter, wife after filing, she wants herself transfer.
That is happening.
We do not know what is happening because that is only adding to the pendency, but no exact relief or no exact progress in the litigation.
Somewhere there are some cases, but not in all cases.
There will be some cases definitely, but somehow the overwhelming majority you cannot understand what is happening.
My lord, one thing if a lordship subject to my lord's consideration, that delay will be there. That
the period of pendency of the application before this court.
Yes, ma'am. Right.
Shall be excluded.
I-14 is there. I-14.
If the petition is filed within the time directed by this court. Yes.
18.
Mr. is after lunch, he is out of station, so kindly take him time.
Your name, madam?
Kranti Prabha Mukhi, my lord.
It says KP Mukhi for the petitioner. Adjournment is sought for in absence of the arguing counsel, Mr. Misra, for the petitioner. Accordingly, the matter shall be listed in the week commencing 16/3/2026.
19.
Yes, please. Defect not removed, Mr. Mukherjee.
This is regarding removal of defect. Registry pointed out that the contempt case is not maintainable. Your Lordship, kindly have a glance, section 10 of the Contempts of Court Act.
Do I have the also? I don't know. Does this come within my determination?
Yes.
The tooth ratio.
Actually,
because not assent is not my bench.
My lord,
the coup provision
DB miscase was allowed to directed the opposite party to give separate precedence.
Impugned order. Which is the impugned order?
Okay.
Impugned order ta coup page re achi.
I am for the wife.
Apna wife challenge କରୁଛନ୍ତି ତ ଗୋଟେ order ku?
No.
Wife ki challenge କରୁନାହାନ୍ତି?
No.
ଆଉ କଣ ଚାହୁଁଛନ୍ତି?
I filed a contempt case in the lower court. Lower court rejected my petition, but given liberty to appropriate forum.
Contempt court file.
Section 10 clearly says that this High Court has ample power to entertain, adjudicate the contempts of its subordinate court.
ସେଟା ରେଫର କରିବେ ନା ଆପଣ କଣ୍ଟେମ୍ପ୍ଟ କୁ କଣ ପାଇଁ କଣ୍ଟେମ୍ପ୍ଟ ଚାହୁଁଛନ୍ତି?
Lordship, kindly have a glance at section 10.
Already glanced. ଆପଣ ସେ ଯୋଉ ଅର୍ଡରଟା କୁ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ସେମାନେ କହିବେ ନା ଆପଣ ଯୋଉ ଅର୍ଡରଟା ରିଜେକ୍ଟ ହେଲା ଆପଣଙ୍କ ପିଟିସନ ପ୍ରେୟାର ରିଜେକ୍ଟ ହେଲା ସେ ଅର୍ଡରଟା ଆନେକ୍ସ କରିନାହାନ୍ତି
କଣ୍ଟେମ୍ପ୍ଟ ପିଟିସନ ତଳ କୋର୍ଟରେ ରିଜେକ୍ଟ କରିଦେଲେ
କାଇଁ ସେ ଅର୍ଡରଟା କୋଉ ଅର୍ଡର ରିଜେକ୍ଟ ହେଲା
and given liberty to your annexure 2, my lord. Exhaust 25, page 31.
original petition domestic violence act रे execution नहीं की
ना
domestic violence act दियो
the petition filed under section 2B and 12(3) of the Contempt Act is dismissed as not maintainable. The petitioner, however, is at liberty to take appropriate steps for enforcement of the order in accordance with section 26 or section 13 of the Protection of Women from Domestic Violence Act 2005.
ସେଟା ଆପଣ ମୁଁ ପଚାରୁଛି
ଆଜ୍ଞା ସେଥିରେ କହୁଛି
ହଁ ଆପଣ ତାହେଲେ
I can approach the
enforcement କରିବେନି ଆଉ ହବ କେମିତି ତାହେଲେ whenever there is a executable decree executable order straight away contempt cannot be initiated if further during execution one may be sent to punished for non-compliance so straight habo then execution ta eliminate ହେଇଗଲା I was asking you that only. So, but the court has, and you have read it, court has said 26 and 31 kind. 20 into bracket 6 and 31 of Domestic Violence Act. Achi, boy, achi. boy kada. ସବୁ ତ ଗୋଟେ ରଖିବେ ଆଉ Domestic Violence Act is a central act. এটা দেখুন স্যার Kindly just read it aloud because I don't have a copy. I have to open the laptop to ବଡ ପାଟିରେ microphone ରେ ପଢନ୍ତୁ.
Upon the failure on the part of the respondent to make payment in terms of under section 1 of the direct the employer or a debtor of the respondent to directly pay to the aggrieved person or to deposit with the court a portion of the wages or salaries to date due or accrued to the credit of the respondent, to which amount may adjusted towards the monetarily payable by the. As
Can you read 31?
31. 31. Penalty for protection order by the respondent. A breach of protection order or of an interim protection order may the respondent shall be an offense under this act and shall be punished within the imprisonment of either description for a term which may extend to 1 year or with fine which may extend it to 20,000 rupees or
how the trial court or this court will bypass this provision?
ତଳ କୋର୍ଟରେ ସାର୍ କଣ୍ଟେମ୍ପ୍ଟ ପିଟିସନ ଫାଇଲ କରିଥିଲି ହି ରିଜେକ୍ଟେଡ।
ଆପଣ ଯଦି ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି ସେଟା ମୁଁ ବୁଝିପାରିଲି।
ଆଜ୍ଞା
ଆପଣ 20 ଧାରାରେ ଆଉ 26/31 ଧାରା ବାଇପାସ କେମିତି କରିବେ? ଆପଣଙ୍କର ଅର୍ଡରଟା ଯୋଉଟା କଣ୍ଟେମ୍ପ୍ଟ କହୁଛନ୍ତି କୋଉ ଧାରାରେ ହେଇଥିଲା? ଡୋମେଷ୍ଟିକ ଭାୟୋଲେନ୍ସ ହେଲା। 26 ରେ ଆପଣଙ୍କର କଣ୍ଟେମ୍ପ୍ଟରେ ଯୋଉ ପନିଶମେଣ୍ଟ ମିଳିବ 26 କି 31 ରେ ମିଳିବ, 31 ରେ ମିଳିବ। 26 ବି ଆଗ ହବ ତାପରେ 31 ହବ।
ଆଜ୍ଞା
ଆଉ ସେଟା ତା ଆଗରୁ କେମିତି ହେଇପାରିବ?
ନାଇଁ ଯୋଉ କଣ୍ଟେମ୍ପ୍ଟ କଲି ସେଥିରେ
ଭଲ ଲାଗୁଛି। ଆରେ ଆପଣଙ୍କୁ କଣ୍ଟେମ୍ପ୍ଟ ଭଲ ଲାଗୁଛି, ବହୁତ ଭଲ କଥା। ଜଜଙ୍କର ସେ ଚଏସ୍ ନାହିଁ, ଜଜକୁ ଫଲୋ କରି 6/31 ଜଜ ଆପଣ କଣ୍ଟେମ୍ପ୍ଟରେ ଯୋଉ ପନିଶମେଣ୍ଟ ଦେବେ ସେଟା ଇଲିଗାଲ ହବ, 31 ରେ ପନିଶମେଣ୍ଟ ଲିଗାଲ ହବ। ଆପଣ ଯଦି 31 କୁ ଅନେଇବେନି ଆଉ କେମିତି ହବ? ଜଜ କହିବେ ନାଇଁ ଆପଣ ସେ 31 ଆଡକୁ ଅନେଇବେ, 31 ମୁଁ ତାକୁ ଶୁଣିବିନି, କେମିତି ହବ? ସେଟା ହେଇପାରିବନି।
ସେଟା ଆଜ୍ଞା ତଳ କୋର୍ଟ କହିଲା ଇଟ୍ ଇଜ ନଟ୍ ମେଣ୍ଟେନେବଲ। Section 10 of the Contempt Act giving ample power to this honorable court to adjudicate the contempt matters which is subordinate to it. Again, High Court चाहिले, this is a new concept I know, therefore I have mentioned it in parallel petition.
This is not a new concept. ଆପଣ ଉଲ୍ଟାଟା କହୁଛନ୍ତି। ଡୋମେଷ୍ଟିକ ଭାୟୋଲେନ୍ସ ଆକ୍ଟ କେବେ ଆସିଲା? ପଢୁନାହାନ୍ତି, ବହିଟା ଧରିଛନ୍ତି। ଆଉ କଣ୍ଟେମ୍ପ୍ଟ ଅଫ କୋର୍ଟଟା କେବେ ଆସିଲା? 1971। ଆଉ ଉଲ୍ଟାଟା କହୁଛନ୍ତି ଆପଣ। Generally, specially was non-derogate.
Section 20.
So, which is the new concept? Domestic violence is a new concept.
Yeah.
The court cannot interpret Domestic Violence Act in derogation.
IPC ହେଲେ ଇଣ୍ଟରଫିୟର କରିପାରିବେ ନାହିଁ।
IPC no.
DB Act ରେ ଇଣ୍ଟରଫିୟର କରିପାରିବେ।
Sir, Contempt of Court Act is a general act. Domestic Violence Act in 2005 is a special act.
Yeah.
So the court cannot, in derogation of the special act, enter into Contempt of Court Act. The reason being the violation of a order in a special statute has been taken care of. When you will bring Contempt of Court Act, like suppose High Court order, non-compliance. Is there any provision, section 26, 31 akin to that? There is nothing. So you are invoking Contempt of Court Act. So that is one way of looking at it. But when it is a special statute and you have got an order in special statute, 26, 31, it cannot be. So the same, and interestingly, the result is same. And maybe I think 31 is more rigorous.
ତାହେଲେ ଆଜ୍ଞା କଣ୍ଟେମ୍ପ୍ଟ କୋଉଠି ଲାଇକ୍ କରିବ ମୁଁ ଜାଣିପାରୁନି।
ଆପଣ ଜାଣିପାରୁନାହାନ୍ତି ଏଥିପାଇଁ ଯେ ଆପଣ ଅବସେସନ ହେଇଯାଇଛି କଣ୍ଟେଣ୍ଟ ପ୍ରତି, ଆପଣ ରିଲିଫ ପାଇଁ ବ୍ୟସ୍ତ ନୁହନ୍ତି। ଆପଣ ସ୍ପେଶାଲ, ଆପଣ କୋଉ କେସରେ ଆପଣ କଣ୍ଟେମ୍ପ୍ଟ ଧାରାରେ ଫାଇଲ କରିଥିଲେ, କ୍ଲେମ କରିଥିଲେ ଡୋମେଷ୍ଟିକ ହେଲ୍ପ, କଣ ଫାଇନାନ୍ସିଆଲ ଆସିଷ୍ଟାନ୍ସ?
ସାର୍ 2 ଇୟର ଫାଇଲ କଲି।
ଆପଣଙ୍କର ଏଇଟା ଗପିବାରେ ସମୟ ନୁହଁ। ଆପଣ କୋଉ ଆକ୍ଟରେ କ୍ଲେମ କଲେ ଇଏ ଆପଣଙ୍କର ଫାଇନାନ୍ସିଆଲ ଆସିଷ୍ଟାନ୍ସ କୋଉ ଆକ୍ଟରେ ନା ଜାଣି ତା ବି ଜାଣିନାହାନ୍ତି? ଆପଣ ମ୍ୟୁଟେଡ ହେଲେ ମୁଁ କଣ ବୁଝିବି? ଆରେ ଆପଣ କୋଉ ଆକ୍ଟରେ ଫାଇଲ କରିଛନ୍ତି ଯୋଉ କ୍ଲେମ କରିଛନ୍ତି ଫାଇନାନ୍ସିଆଲ ଆସିଷ୍ଟାନ୍ସ ଅଣ୍ଡର ହ୍ୱିଚ ଆକ୍ଟ? ଆଜ୍ଞା ଆକ୍ଟ ତ କିଛି ନାହିଁ ଆଜ୍ଞା। Sir, which act you had filed, you have forgotten also. अब ମୁଁ କଣ କହିବି ତାହେଲେ?
Section 10 of the Contempt Act କହିଲେ ହାଇକୋର୍ଟ କରିପାରିବ।
ଆପଣ ଯୋଉ ଫାଇନାନ୍ସିଆଲ ଆପଣ କୋର୍ଟ କୁ କାହିଁକି ଗଲେ? ଫାଇନାନ୍ସିଆଲ ଆସିଷ୍ଟାନ୍ସ କ୍ଲେମ କଲେ କୋଉ ପ୍ରୋଭିଜନରେ? ଆପଣ ଆପଣ ପିଟିସନ ଦେଖିଛନ୍ତି କୋଉଥିରେ ଫାଇଲ କରିଥିଲେ?
ଡିସିସନ କିଛି ନାହିଁ।
ପିଟିସନ ସାର୍ ଅର୍ଜି
ଆଜ୍ଞା
ଅର୍ଜି ନକଲ ଅଛି କୋଉଥିରେ ଦେଖୁନାହାନ୍ତି କଣ ପ୍ରୋଭିଜନ ଫାଇଲ କରିଛନ୍ତି?
ହଁ ଡାଇରେକ୍ସନ ଦେଇଛନ୍ତି। I have quoted it. ମୁଁ ଆଜ୍ଞା annexure 1 ରେ ଡାଇରେକ୍ସନ
ସାର୍ ଆପଣ ମୁଁ ପଚାରୁଛି ଆପଣଙ୍କର ଗୋଟେ ଜିନିଷ ପଚାରୁଛି ଟିକେ ସେଇଟାକୁ ମୁଁ ଆପଣ ମୋ ପ୍ରଶ୍ନ ବୁଝିପାରୁନାହାନ୍ତି ମୁଁ ଆଉଥରେ ରିପିଟ କରିବି।
ଆଜ୍ଞା ପୋଲିସ ପ୍ରୋଟେକ୍ସନ ପାଇଁ ଡାଇରେକ୍ସନ ହେଇଛି।
କୋଉ ପ୍ରୋଭିଜନ ସେଇଟା?
IIC ପାରାଳକ୍ଷ୍ମୀ PS କୁ ଡାଇରେକ୍ସନ ହେଇଛି। ସେଟା that is annexure 1
ଆପଣଙ୍କର ପିଟିସନ ଇଜ ଆଲାଉଡ ଇଜ ପନିଶ୍ଡ
କରିଛି ସାର୍ ପିଟିସନ ବି ଦେଇଛି ସେମାନେ କିଛି
ଶୁଭୁଛି ନା ଶୁଭୁନି? ଆରେ ଏଇ ବହିଟା ପାଇଁ ମୁଁ ଦେଇଦେଲେ ଆଡଜଷ୍ଟମେଣ୍ଟ ଏତେ ହେଇପାରିବନି ଏଥିରେ କଣ ହବ? ଏଇ ତ କେସ୍ ସରିବନି ଏଟା କେଶବାନନ୍ଦ ଭାରତୀ ହେଇଯିବ। ଆରେ ଆପଣଙ୍କର ଏଇ ଯୋଉ ବହିଟା କୁଆଡେ ଗଲା? ଆପଣ ବହି କଣ କଲେ?
ଆଜ୍ଞା
ଆପଣ ପିଟିସନ କୋଉ ଧାରାରେ ଫାଇଲ କରିଥିଲେ ଦେଖନ୍ତୁ ଆପଣ ଯୋଉ କ୍ଲେମ କଲେ ଫାଇନାନ୍ସିଆଲ ଆସିଷ୍ଟାନ୍ସ
ପିଟିସନରେ ସାର୍ ମୁଁ କୋର୍ଟ କରିଛି।
ପଚାରନ୍ତି ସାର୍ ଆପଣ ଯୋଉ ଗଲେ ପଇସା ମାଗିଲେ
ଆଜ୍ଞା
କଣ ପାଇଁ ଯାଇଥିଲେ କୋର୍ଟକୁ ପ୍ରଥମେ?
ସେଇଟା ଆମେ ଦେଇଥିଲୁ ଯେ ତଳ କୋର୍ଟ କହିଲା ସେପାରେଟ ରେସିଡେନ୍ସ ଦେବା ପାଇଁ ଏବଂ ପୋଲିସକୁ ଡାଇରେକ୍ସନ ଦେଲା ପୋଲିସ ପ୍ରୋଟେକ୍ସନ ପାଇଁ।
ସାର୍ କଣ ମାଗିଥିଲେ ମୁଁ ପଚାରୁନି ସାର୍ ପ୍ରୋଭିଜନ ସାର୍
ମୁଁ କହିଛି ପରା ମୁଁ ଲେଖିଛି ସେଟା କହୁଛି
ଏଇଟା ନୁହେଁ ମୂଳ ପିଟିସନ କଣ୍ଟ୍ରିବ୍ୟୁଟରରୁ ଆରାଇଜ କରିଛି ମୂଳ ପିଟିସନ
ହଉଛି 2E ଆଉ 13B ରେ।
ତା ପୂର୍ବରୁ ଆପଣ ଦେଖନ୍ତୁ କୋଉ କେସ୍ ଉପରେ ଆସିଲେ କଣ୍ଟେମ୍ପ୍ଟ କୁ ସେ ଫାଇଲଟା ତ ଆଣିନାହାନ୍ତି ବୋଧେ ମୂଳ ଫାଇଲଟା ବି
ଆପଣ 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 କଣ୍ଟେମ୍ପ୍ଟ ଅଫ କୋର୍ଟ ଆକ୍ଟରେ କଣ୍ଟେମ୍ପ୍ଟ ଅଫ କୋର୍ଟ ଆକ୍ଟରେ ଆପଣଙ୍କୁ ପଇସା ମିଳିଥିଲା କି? ଠିକ ଅଛି
Annex 2 page 31 এটা section 2B of the Contempt Act।
ଶୁଣନ୍ତୁ ଅଭ୍ୟାସ କରନ୍ତୁ ସବୁବେଳେ ବ୍ରିଫଟା ପଢିବେ ଇଆଡୁ ସିଆଡୁ ପଢିବେନି। ଆପଣ ଯାଇଥିଲେ ଗୋଟେ କୋର୍ଟକୁ ଗଲେ ପଇସା ମିଳିଲା ଆପଣଙ୍କୁ ଡାଇରେକ୍ସନ ହେଲା କୋଉ ପ୍ରୋଭିଜନରେ ଯାଇଥିଲେ?
2B and 12(3) of the Contempt Act।
ବହିଟା ଦେଖିଲେ ଆପଣ ବହିଟା ଧରିଛନ୍ତି 2B ପଢିଲେ ସେଇଟା 2B କୋର୍ଟ ସେଇଟା ଅଛି। ଟୁ ବି ପଢନ୍ତୁ। କଣ ଆପଣ ବହିଟା କଣ କଲେ କି ମୋର ଯୋଉ ନେଲେ? ଆରେ ତଳେ ବହି ରଖିଛନ୍ତି ଉଠାନ୍ତୁ ମିଷ୍ଟର ମୁଖାର୍ଜୀ ବହିଟାକୁ ତଳେ ରଖିଦେଇଛନ୍ତି।
ନାଇଁ ସାର୍ ଦେଖୁଛି ମୁଁ ଅଛି ମୋବାଇଲ
କୋଉଟା ଆପଣ ତ ବହି କାଗଜ ଖୋଲୁଛନ୍ତି ବହିଟା କୁଆଡେ ଗଲା ଆପଣଙ୍କର? ସାର୍ ଭାରି ଇଜ ବୁକ୍
2B ସାର୍ ମୁଁ ଦେଖୁଛି।
ଆରେ ସେଇଟା ଆପଣ ଆରେ ଡୋଣ୍ଟ ଗେଟ୍ ଅବସେସ୍ଡ ୱିଥ୍ ଆପଣ 2B ଆପଣ ବହିଟା ଦେଖନ୍ତୁ ଆଗ। The Lord Counsel, sir, I have to record that you are disoriented and not answering. I have no choice. Since it is a live proceeding, I cannot also avoid you.
Sir, 2B କହିଲା
sir ଆପଣ ଶୁଣିବେନି sir. ଆପଣ 2B କହିଲା ବାରମ୍ବାର କୁହନ୍ତୁନି। ଆପଣ ଯୋଉ କୋର୍ଟରେ ପ୍ରଥମେ ଫାଇଲ କଲେ ପଇସା ମାଗିଲେ ଭରଣ ପୋଷଣ ମାଗିଲେ ଘର ମାଗିଲେ କୋଉ ପ୍ରୋଭିଜନରେ?
2B and 13
ଅଛି।
সেটা ডিভি অ্যাক্ট র
সেটা হচ্ছে ডিভি অ্যাক্ট গোটে অ্যাক্ট সেটা ডিভি অ্যাক্ট কোন সেটা ডিভি অ্যাক্ট উঠাନ୍ତୁ তଳେ ଯୋଉଟା ତଳେ ରହୁଛନ୍ତି ତାକୁ ଉପରକୁ ନିଅନ୍ତୁ ଉପରଟା ତଳକୁ ନିଅନ୍ତୁ।
Executive under section 31, section 28, read with section 25(3) of the said act.
ଆପଣ ଭରଣ ପୋଷଣ ଅର୍ଡରଟା ଆଣିଛନ୍ତି
31 ରେ
अरे आपनकर जो ऑर्डर टा आपनकर फेवर रे अछि ऑर्डर टा देखिसंती
ଆଜ୍ଞା
काई सेटा
31 ରେ ପେନାଲ୍ଟି କହିଲା 25 28 ଅର୍ଡର ପୋଷଣ ପୁରା ପଢୁଛି ପଢିଛି
ଆପଣ ଗୋଟେ କାମ କରିବେ ମିଷ୍ଟର ମୁଖାର୍ଜୀ ଆପଣ କାହାକୁ ଭାବନ୍ତି ହାଇକୋର୍ଟ ରେ ବେଷ୍ଟ ଓକିଲ who is the best lawyer in this court according to you kiye se I will issue a madam he will appear.
Accordingly, the petition filed under section 2B and 13(3) of the content of court is dismissed, not maintainable. The petitioner however has liberty to take appropriate.
Mukherjee, I cannot avoid your submission because it is a live court. I have to record that you are disoriented, you are not listening. Because it is all recorded. I have been asking you under which provision you sought for maintenance, financial assistance and residence.
Okay.
Which is that provision in which law?
Chapter 26 of section 31 of the DV Act मिलिबो
15 मिनट लागला सर 15 मिनट 15-20 मिनट The petitioner had filed an application under section 26 read with section 31 of the domestic violence
31
of the protection of domestic violence act 2005. The said act is a special statute brought in the year 2005. The act also provides the enforcement mechanism of the orders passed, such as section 20 into bracket 6 and section 31. For enforcement of any order passed under the said act, the petitioner has and shall prosecute remedy available under the said special statute. Recourse to any other statute such as Contempt of Courts Act would be violative of the principle generally specialibus non derogate. देखिए लिखिए पड़ो. Stop, which means which indicates that a special statute cannot be interpreted in derogation of other general statute. Sorry, ultada koi dil. The special statute cannot be interpreted in derogation by referring to a general statute. Accordingly, at this stage, the petitioner seeks, the learned counsel for the petitioner seeks leave to withdraw the application. Withdraw karibe na dismiss karibe kon karibe? Withdraw na dismiss? Sir?
Again?
At this stage, the learned counsel for the petitioner submits that he will prosecute the available prosecute the available remedy under the Domestic Violence Act under se pura likhibe the Protection of Women from Domestic Violence Act 2005.
No, but we need to come quick.
And the present application is not pressed. Memo of date. Madam Misra, just write that sentence that he wants to proceed. Proceed in accordance with 26 and 31 of before the appropriate court. ଆପଣ ଯୋଉ କଣ୍ଟେମ୍ପ କୋର୍ଟରେ ଏଠି କଣ୍ଟେମ୍ପରେ ତାଙ୍କର ପାୱାର ନାହିଁ ତା ରିଜନ ହଉଛି ଯେ ସ୍ପେଶାଲ ଷ୍ଟାଚ୍ୟୁଟରେ ଅଛି ଜେଲ ଜୋରିମାନା ଯାହା ହବା କଥା ହବ ସୋ ଦ କୋର୍ଟ କ୍ୟାନଟ୍ ଓଭରରାଇଡ୍ ଏ ଷ୍ଟାଚ୍ୟୁଟ
ସେ ରିଜେକ୍ଟ କଲେ ବୋଲି କି ନା ମୁଁ ଆସିଲି
ନାଇଁ ନାଇଁ ମିଷ୍ଟର କରେକ୍ଟ ସାର୍ ରିଜେକ୍ଟ କଲେ ଯେ ଆପଣ ତ କୋର୍ଟ ତ ସେଟା ବି ଲେଖିଲେ କୋର୍ଟ ଇଜ ଅଲସୋ କନସିୟସ୍ then why the content of court act is not applicable in the case the reason being execution is there punishment is there 125(3) ଦେଖନ୍ତୁ content of court ଆପଣ କହିପାରିବେ content of କିନ୍ତୁ 125(3) ଅଛି ଆପଣଙ୍କ civil imprisonment in case of a decree କାହିଁକି ଅଛି ତାହେଲେ ସେ ତ content of court act ରେ ପଡନ୍ତା because the statute itself is self sufficient, it's a complete code.
ସେତିକି ଆପଣ ଅବଜରଭେସନ ଦେଲେ ଦ୍ୟାଟ ଇଜ ଏନଫ୍ ସେତିକି ହେଲେ ତଳ କୋର୍ଟରେ ଆମେ ତାକୁ
କହିପାରିବିନି କଣ୍ଟେଣ୍ଟ ଅଫ କୋର୍ଟ ପାଇଁ ମୁଁ କେମିତି କହିବି ତାପରେ ମିଷ୍ଟର ସାହୁ ଫାଇଲ କରିବେ ତା ଆର ସାଇଡ ପାଇଁ କହିବେ ଯେ ସେ ଲ କିଛି ଜାଣିନାହାନ୍ତି ବୋଥ ମିଷ୍ଟର CR ସାହୁ ଆଣ୍ଡ JR ସାହୁ memo of time. Yes, Mr. Kindly just write that line. That much for them not pressed. That liberty is to be given. Memo of date is taken filed by the. ଆପଣ ବହିଟା ନେଇ ଆସିବେ ମୋ ବହି ଏଠୁ ବହି ନେଇ ଦେଇଦେଲେ ମୋ ନାଁ ସେଠୁ କହିବେ ଯେ ଲାଇଭ କହିଲେ ଦେବା ପାଇଁ ଠିକ ଅଛି ବହିଟା ଦରକାର ଦେଇଦିଅ ସେ ନେଇ ଆସିଛନ୍ତି ଦଉନାହାନ୍ତି ଦେଖିକି ଲେଖିଦେବେ ଆପଣ 2631 କଣ ଲେଖିବେ memo indicates that the petitioner the memo of date is filed indicating that the petitioner will avail appropriate legal remedy under the protection of so and so 2005. Memo is taken on record. Yes, next.
Item 20.
এটা আর্জন করଥିଲି কি মেনশন করଥିଲି item 20 লেখন্তু petitioner the opposite party Mr. PK Mahanti additional standing. OP 1 and 2 होचंती Mr. PK Mahanti standing counsel. OP 3, 4 and 5 none. None appears for the petitioner when the matter is called to grant further opportunity. List on আজি কেতে তারিখ হচ্ছে 22 list on 28 list on 28 2 20 26
21.
My lord,
look for orders for him. Look for orders on notice. Yes, please.
My lord,
21 see place for adjournment in the absence of our leader.
date fix कर दो
No, date we are giving. Mr. SK Jena. This is SK Jena. This is SK Jena for the petitioner. Miss Dipti Dhal. Up to notice matter would allow some time so that otherwise it doesn't. Right, sir. Right, madam. Dipti Dhal on behalf of the opposite party. For the petitioner seeks for adjournment in absence of her leader. Stop. The Lord Counsel for the opposite party submits that the interim order is continuing against.
My lord, ସେ ପର୍ଯ୍ୟନ୍ତ ବି ପଇସା ପାଉନାହାନ୍ତି ତଳ କୋର୍ଟରେ ହଉଛି ଷ୍ଟେ ଅର୍ଡର 8,000 ଟଙ୍କାରେ କରିଦେଇଛନ୍ତି ସେ ଗୋଟେ ମା ପୁଅ 2 ଜଣ
ସେ ଆଜ୍ଞା ଆପଣ ବି ସେମିତି କହିବୁ ସେମିତି ଆପଣ ଯୋଉଥିରେ ହଜବେଣ୍ଡ ପାଇଁ ଆପିଲ କରୁଛନ୍ତି ସବୁଟା ଷ୍ଟେ କରି ପକେଇଛନ୍ତି it's a competing equally.
ସେ ପିଲା ବି ପାଠ ପଢୁଛି ପଢି ପାରୁନି 4,500
ସମାଧାନ ହେଇପାରିବନି
ଆର ସପ୍ତାହରେ
ଆଚ୍ଛା ଠିକ ଅଛି ଏଇଟା ରିସିଭ୍ କରି ନମ୍ବରଟା ପକେଇଦେବେ list in the week commencing submits that continuing and to the detriment of the opposite party and adjournment may not be granted. Stop. The matter shall be listed in the week commencing 16/2/2026. Yes, next.
Oh, please, madam.
Yes, please. हाँ जोटा जोटा आपण अर्जुन नहीं छंती सेटा को कॉल करो तुनी नेक्स्ट को जान
23
तले
23 complied with, we have also filed the so cause, but that is not on board. Already filed on 20th.
Mr. Vijay Kumar Porda for the petitioner.
My lord,
Mr.
my lord,
P.K. Sahoo, additional standing counsel for the opposite party.
I have filed the objection in the compliance order, my lord. Did not properly comply.
ठीक अछि आपणकर again this has become a RPFM or a TRPC. Please examine the law on this.
AC chair.
They must have done something, otherwise they will never file affidavit. Upon agreed by the order complying, but part compliance, you have to challenge that on merit.
No.
Unless you challenge that on merit.
Neither partly complied nor.
I am not saying you. I am granting you adjournment, but I am discussing with you.
Yes.
We pursue this litigation. They will say compliant. You will say not compliant. It goes to nowhere. Upon the substantive challenge, challenge it. Don't delay the challenge.
AC chair 24 ro actually compliance. That is the letter of rejection.
ठीक अछि. It is submitted by Mr. The learned additional standing counsel that the affidavit indicating has been filed on
21-26.
48-26 yesterday. So it will not come.
Copy, sir.
Copy of the affidavit. Copy of the affidavit has been served on the learned counsel for the petitioner. The learned counsel for the petitioner submits that he shall obtain instruction. List in the week commencing?
Nothing.
9-3-26. Yes.
24. May please, my lords.
This is with R. Singh for the petitioner.
Yes, yeah.
Mr. Mahapatra, D. Mahapatra for the opposite party.
Yes, ma'am. I think time, my lord.
My lords, there is an interim order that is operating, and my lords, I have not been paid any maintenance since my lords date of filing, that was from the year 2020, my lords. The maintenance award is only 6,000 rupees, my lords.
You proceed in execution?
No,
my lords, there is a stay order, my lords.
Correct. Did you proceed in execution?
My lords, stay after the judgment, my lords. I cannot proceed in the execution, my lords. Lords, may just clarify that, my lords.
Madam, when can you file?
Yes, my lord.
No, at least I have understood it correctly, because this litigation will continue because of the stay order.
Yes,
my lords.
Yes, when do you want?
Second after February, so I will take some instruction from my client. And second thing is the opposite party wife is as RI in assistant review inspector. That's why.
24, 125.
D125.
125 RI को दे परिबेनी बोलते provision किछि नहीं.
No, I am not working any mu काम कोनी mu बेकार. I have also filed section 24.
बेकार रे आपण बेकार थिले 125 रे अछि देखिचंती. Whenever you are submitting in a court, make a legally nuanced submissions. Repeated request data.
The wife has.
Our discussion should not be void. What is the material on record before the trial court?
That's record.
To find that you are a bekar.
Yes, that record was there.
तापर आपण ऑर्डर हैला पर काम करिवेनी सेटा भी हबनी आपण देखिया को पड़िबो from the on the date of marriage you are bekar.
Yes, ma'am.
So देखने तो कोठी अछि
admitted fight by the wife, my lord. Wife is also stated in the cross examination that my husband is not doing any job, any service. She is in the deposition.
Examine the law on this. You beg borrower still or you work as a daily wager. The daily wage is now 600. So per month it is 18,000. Out of that, at least 8,000 you can give. So what is the amount?
My amount is 6,000 per month.
It is not even 8,000.
My submission. The wife has filed a divorce case between the learned family court. Regarding that, I have filed section 24 of the interim maintenance from my wife. I am totally
125 रे आपनकर से जोडा आर्ग्यू करछंती, you are arguing a 125 petition.
Yes, ma'am.
You read 125 and the law on the 125.
Adjournment.
So I do not if I start believing all of you, and then I've been really making bad orders, because I have not read all these things what you are saying. 125 percent the scope nahi examination.
Adjournment,
For a-
adjournment also.
being a able-bodied person, whatever you are earning, that is your liability. So in a conservative estimate, 8,000 you have to give, now you are giving 6,000. Yes. 24 may be allowed in your favor. That's a different thing.
The adjournment, if my.
The learned counsel for the petitioner seeks adjournment.
Yes, take the instruction.
The learned counsel for the opposite party opposes the same, submitting that due to operation of the interim order, the opposite party wife in the marriage is not getting any benefit of the direction of grant of maintenance. List in the week commencing 23/2/2026, when efforts shall be made for disposal of the application. Yes.
My lords, may I pray one thing, my lords? Let him at least pay the monthly maintenance. Let there be a stay of.
You see, I mean, that order I have not passed. I have to honor. So be little bit more patient. I understand. Your point is well taken.
My lords,
And because your learned colleague also she understands your point, so that is how she is saying more mukiche kama koni mu bekar. Otherwise, she wouldn't have argued that. When the lawyer has the advantage or privilege of making outlandish submission, when there is nothing to argue. Yes. So since time is over, we have to take up the special assigned matter. So all the matters will be. Special based matters are there. So rest of the matters you want a date. So
My lord, item 34 again.
yes, please. Page wise लिखे दो आता है. Item 3 है last matter. We finished up to 25.
25. My lord.
25, my lord, adjournment, my lord.
25 date कर दियो.
My lord, I am appearing for opposite party.
No, I will simply posting it. We are saving time by that. Simply computer पे posting कर दो. आगे? हाँ, ये बड़ा पैटर्न कौन सी सुनी बे? हाँ. हाँ, yes, next. So Banjadev.
Yes, Lord.
Date.
26.
अच्छा, 26 से आया करो.
2-3.
हाँ.
Two comments, 2-3.
Okay. Call करो तो सर.
28.
27 सकाळे से आयोजन कर दीजिए. से कॉलेज आमे नाथ सर को पचलु से कहले जेबे चाहे से बे.
I am the wife, my lord.
You cannot be the wife. You cannot be the wife. I hope this is a live streaming and your better half is not watching the proceeding.
In item 28.
Yes.
In item 28, yes. In the lower court, I have filed a memo to withdraw that petition, which he wants to transfer.
Withdrawal transfer कौन हो?
No. ये जो transfer.
पहले आपण सुनतु. आपण यार you place the matter in perspective. Transfer file हिला परे आपण withdrawal file करथिबे.
हाँ सब
केमती
मु ट्रांसफर डेट 8/7/2025 रे विथड्रॉ करे पे ड्यू टू स्टे ऑर्डर इट कैन नॉट बी विथड्रॉन.
मेमो दे दियो जॉइंट मेमो.
मु गोटे देई दोची एटा को लोअर कोर्ट रो ऑर्डर टा.
नहीं ठीक अच्छी लोअर कोर्ट ऑर्डर कौन हबो? आपण तो कहउचंती व्हाई दे विल ऑब्जेक्ट फॉर विथड्रॉल इफ दे वांट द पिटिशन व्हिच विल नॉट बी देयर. You filed the withdrawal after they filed the TRPC.
Yes, your lord.
So then how you are saying that they are objecting? The memo दियो.
Memo दोची पर withdrawal.
हाँ से कागज दियो तो no you state that. आपण केबे withdrawal टा फाइल करले.
Yes, your lord.
से जो CP टा सेटा that and Mr. Sahoo will sign it. So the matter closed here. TRPC why it will be kept pending here.
Yes, your lord. Yes.
और जोटा लोअर कोर्ट ऑर्डर दे दियो.
लोअर कोर्ट ऑर्डर टा सर्टिफाइड कर दो.
नहीं I will return it. I will just dictate it. जल्दी. Record. But you write clearly those two lines. Mr. C.R. Sahoo for the petitioner. Mr. B.K. Misra for the opposite party. The learned counsel for the opposite party submits that नहीं ता पूर्व ओपनिंग पैराग्राफ लेखो तो कंप्लीट करे पड़ियो the petitioner wife is before this court seeking transfer of the CP case number 314 of 2024 pending in the court of the Lorded Judge Family Court Baripada to the court of Lorded Judge the Lorded Family Judge Cuttack Para. It is submitted by the Lorded Counsel for the opposite party that during pendency of the said CP the opposite party had moved. The opposite party husband had moved for moved the memo before the Lorded Judge Family Court Baripada, Mayurbhanj, stating that he doesn't want to proceed with the case. On the same date, the counsel for the respondent was present. Due to pendency of the present TRPC, the Lorded Judge Family Court Baripada had directed the present opposite party petitioner to obtain instruction regarding the status of the case pending before this court. Today, memo is filed by the Lorded Counsel for the petitioner, stating the above facts and indicating the observations, public orders of the Lorded Judge Family Court, Baripada. In view of the memo filed by the opposite party husband in the CP, the present the TRPC ଆପଣ ଏତେ ଲମ୍ବା କଣ ଲେଖୁଛନ୍ତି 4 ଲାଇନ ଲେଖିବେ ଯେତେ ଅଧିକା ଲେଖିବେ ସେତେ କନଫ୍ୟୁଜନ the TRPC stands disposed of. Copy of the memo is also served on the Lorded Counsel for the petitioner. Upon production of the certified copy of this order, the Lorded Judge Family Court shall proceed to pass orders on the memo seeking withdrawal of the CP pending before the said court. Urgent certified copy as per rules, but is to act upon production of the copy of the order obtained from the official website of this court. Registry shall forward copy of this order to the Lorded Judge Family Court, Baripada, to be tagged to the file of CP number 314 of 2024. Yes. Yes, next page call kar diyo section. Quick. The page 4 no. Actually, since I have completed the board, so already time is over since 3:15. So because you are saying that it should be listed, all the matters will be listed. Okay. So if it is at 34, madam?
My lord, 34 it urgency अच्छी से
so 34
संपूर्ण बिकिया लगी
सबुड़ा का लिस्ट आसी 34 गोटे पर्टिकुलर डेट कोहंतु से वीक रे कोहंतु कर देबे
नेक्स्ट वीक जे कोन से
नेक्स्ट वीक हबनी कने वर्किंग डे कम अछि आ गोटे
सर
नो वीक कमेंसिंग नो दुई
मान
ठीक 35 से सबुड़ा का हे जिवो आपण जदि चाहउचंदी यू कैन जस्ट गिव हिम सम टाइम बिकॉज़ दिस इज अ कंटिन्यूइंग डेट सो ही डजंट हैव टाइम टू yes it will be done it will be done. Some are spilled over to say first week of March, otherwise it is adjusted.
35 ଟା ସରି
ଦେଖନ୍ତୁ ଗୋଟେ ମାସ ଭିତରେ ସବୁଗୁଡାକ ଯଦି ହେଇପାରିବ ନା
35 ଟା ସରିଯିବ
ୟେସ୍
Special list, item 1.
Please, yes, sir.
this list ଅଲଗା ଅଲଗା ଅଛି ଆଜ୍ଞା ଲିଷ୍ଟ ତଳେ ନାଇଁ ତଳେ ଅଛି ଲିଷ୍ଟ 40 ରେ ସରିଯାଉଛି ମୁଁ ଆଜ୍ଞା 7 out of 7 ଦେଖି ସାରିଲିଣି ଆପଣ ଆଉ ଥରେ ଦେଖିବାକୁ ପଡିବ ଅଲଗା ଅଛି ଲିଷ୍ଟ ଅଲଗା ଅଛି yes please
Malo. I'm in the second, third, and fourth, and fifth matters. And the trend is in the first lead matter problem.
Ajay, understand the Honorable Apex Court have directed the matter to be listed, to be placed before the Honorable the Chief Justice, and a special bench shall be constituted. So, my understanding is correct.
Yes,
all the matters.
Correct.
All the matters.
Correct. So your lordship is a special bench problem.
So it is a subject matter of my roster also, as I understand.
Subject matter of?
My determination now, as per the
yes.
roster, this is also my assignment also.
Now it's your lordship's assignment.
Yes.
Now I'm in the my friend is in the lead matter problem, and I'm on the subsequent matter. But difficulty is what happened in this matter. The Office of the Advocate General served as the counter on 22nd 12/2025, the last 2 days of the vacation. So somebody has received it in my office in a rush. It was not brought to my notice. In the court, I found out that actually counter and vacation and everything has been filed. I need 3 weeks time to respond. March 31st is the date fixed by the Supreme Court, outer limit. That's all right. If it's not finished by then the interim orders may be taken up. We all have interim orders. Probably my friend also has an interim.
That is the.
So I was only requesting.
So what is the matter? A brief.
This is my lords relating.
This brief.
This is what happened in various stages broadly. My friend's thing, I'll also he'll facts from in his own perspective. My fact is that, my lords, there was a mine. That mine was leased out in the name of my father. Then
minor mineral or major?
Major.
Major.
I don't know. This order pertains to only major minerals. No minor.
Even a post amendment also, it is a major mineral.
It's a major mineral.
Because post amendment certain
minerals have migrated, but it's a major mineral. I don't know. And my lords, this order says, I don't know in context in which writ petition. I'll have to need some time to look up that also.
Yes, because. What was the SLP before the
Shah Commission's report? It stemmed from the Shah Commission and my lords Goa Foundation.
Yes.
And Honorable Justice
Patnaik's judgment.
Goa Foundation. Badan Lokur's. Justice Badan Lokur's
judgment regarding payment of
that
certain egregious activity, so they have to pay.
No, the ore removal was done. At that time, the IBM permission was not strictly taken in all was taken, but the limits of IBM mining limits were violated. It was not strictly enforced. So this issue went before the Shah Commission. Shah Commission said that no, if you have violated the quantum as prescribed in the IBM report, it will be treated as excess mining and it is illegal. So therefore, my lords, Honorable Justice Lokur said no, you have to pay, and some quantum was fixed up also, one penalty and market price. Compensation and penalty was fixed up. So accordingly, it was calculated at 60,000 crores probably. If I remember the figure, it was in the region of 60,000 crores. Then, my lords, what happened? There are various cases. So various, they went for a review and all. It's a checkered litigation. They went for a review. The lessees went for a review. It remained pending for some time. Then the review was dismissed.
And then the issue came up that there were a lot of ores which were already mined, but when stoppage orders were passed, stacked in the ores, in the mines. So therefore, again a formula was reached that the state may allow the lessees to release the ores, and the ores will be sold under a committee specially appointed. Justice Patnaik was also a part of that committee. That money will be also utilized for repayment of the 60,000 crores, as a result of which bulk money was paid off. So some few thousand crores probably were left. Major payments were done by all major lessees and all that.
By selling off of the stacked mineral.
Yes. They were all mined there. So therefore, they were officially mined, they were lessees, official lessees. So it's a question of extra. So the act was brought into operation. They said that you will apply the penalty and formula. You sell the mine because the ore belongs to me. My mining period is not over. So I sold the mines and paid off. Major. This was the formula, and all the mines. Supreme Court started series of interim orders on Supreme Court. All benches passed orders. Then, my lords, what happened? Some lessees, they raised other issues, technical issues regarding my lords. Some mines were leased out to, given out to other raising contractors where money was due and all that. So on various pleas, they came on various merit pleas, they came challenging the things before the High Court, and High Courts have granted stay. There were also some cases where, my lords, if my memory serves me right, including my case, that where we are not connected with the mine. The mines was in the name of the father. These are all legal heirs who were not involved in the mining, who were not connected, and much after because it's after all the money due. So, the normal process of Recovery Limitation Act and all those issues will be open to be argued, and that's also the law.
Mr. Lenka, you take your seat. Mr. Sahoo also. Let Mr. Palit just give a brief background or whatever. Mr. Lenka supplement.
On various pleas, we also came saying that we are no way connected with this mining operation. We don't even know. Then our minings have been stopped earlier, and various other points that we have taken. On those points, including the point of limitation, we were there, we came before this Hon'Ble. And we also said one more thing, we never even noticed during the recovery period proceedings. Collector never issued us notice, we were never even substituted. There was no substitution in the mines also. So, therefore, the proceedings possibly may not lie against us. And also, without. So, rightly or wrongly, the point. So, therefore, the Honorable Court granted us interim order and protected us, and directed a counter to be filed. Now, so this is my case. My learned friend's case would be, on fact, it would have a little different.
My case is a little different because I have approached this Honorable Court challenging the order of the collector that is under the OPDR Act. Because without determining the amount to be paid by all the petitioners I am representing, my lord, OPDR case was initiated against them. They filed objection under Section 8 of OPDR, denying.
Filed the OPDR?
The government filed.
Government filed. Represented through the Deputy Director. Assistant Director.
Yes.
Collector.
DDM. Collector is the authority. Initially, it was before the sub-collector. Thereafter, the question of jurisdiction arose.
The amount was not quantified. Are you serious?
Yes, my lord.
No, never quantified.
No. Prior to that, it was never.
Sahoo.
Yes, my lord. It is quantified, but he is disputing that. The certificate.
Not notification.
Please don't be anxious that I'm hearing on merits. You have heard Mr. Palit.
There is a notice which has been stayed by the Honorable, which is the subject matter in the first case.
OPDR কথা নাই আজ্ঞା OPDR କଥା ପଢିନି ଆଜ୍ଞା ଆପଣଙ୍କର OPDR ପୂର୍ବରୁ there was a statutory under the MMDR Act कि जोथिरे MMDR I have serious doubt. I have first time seeing it is a single bench matter. Of course, OPDR is a single bench matter. OPDR is a single bench matter. So his contention is prior to the OPDR Act there was no quantifiable demand. That he is saying.
Demand is
you are oversimplifying it.
No, demand is
obviously the OPDR is for a demand.
Yes.
Made by the OPDR authority. But what his contention is a little bit nuanced.
We have filed our counter also saying that
And
there is a
Apollo,
demand.
today we are, it's a preliminary hearing.
There is
But
a
I said thrice, Mr. Lenka, are you sure that there was no demand or quantified demand?
He challenged in the High Court. High Court already stated that condition of stay. No. And there is a direction that stay order will be vacated on the date.
That's problem. Court jurisdiction as a mining demand. Be sure that we are on OPDR, but his contention is little bit nuanced. He says that there was no demand raised by the authority asking him to pay quantified demand prior to the OPDR. Sir, OPDR is unpaid dues.
Yes, that has to be.
So what was unpaid, that is not quantified. That is his submission.
Not correct.
We also file objection to that extent that since so demand cannot be made. That is why we file objection and the collector rejected the same. Against that, we have preferred the appeal before the RDC. The appeal is pending. During pendency of the appeal, they took step for taking possession of the landed property. The courts you action.
I mean, just like a revenue demand, they are doing it for public demand.
Yes. Difficulty is we have filed the vacation of interim order and other things. On the ground is the count, though the counter was filed immediately, Miller.
Mr. Sahoo, you have to assist all of us, not only me.
No,
when you are listening to your lauded colleague, you have to assist him also in your response.
Yes, sir.
But you are not going there. You are going on, you are stuck with OPDR. Please think beyond OPDR.
Yes.
OPDR, he is not disputing that there is OPDR proceeding that has been challenged. He just now says that in the OPDR, he has said that it is not a quantified demand made to me so that I will pay. So what would be your response? You will simply show the court, this is the demand made by the DDM, this remains unpaid. Counter file
my answer is state has filed the counter long back. But even if the 10 dates have been given and there is a stay of 40 crores, Miller, no rejoinder is filed, and now the matter is normally this is the first date. I have no objection for adjournment. But
I will record that.
Yes,
I will record it and I will record that you are not showing the demand notice.
No.
The DDM's demand you are not showing and record that.
No.
You don't make it a child's play, Mr. Sahoo.
No.
Don't make extravagant submissions.
No,
you are not doing any charities.
Submission.
No, you show me. It is submitted by the learned counsel for the. Mr. Sahoo, you have to allow the court to function.
So
make it a joke.
Whatever is only for.
So you can joke to the court.
I'm not saying.
You are being asked why you are not responding. I don't understand this. I'm asking you, show the demand by the DDM making the demand. Show it.
Lordship is not going into merit today, Lord. That is.
I am going into merit.
My only
pretentious submissions that as if the court is responsible.
I'm not saying
this is the last thing I am expecting from anyone. No, this is a special bench. I can't sit like this.
No, my endeavor is to appreciate for appreciation that matter requires.
So don't pretend that I'm not appreciating your contention.
I'm hearing because
today I'm hearing earlier state.
Yes.
I'm hearing and recording the submit. Mr. WPC 12358 of 2024. Mr. Niranjan Lenka for the petitioner. Mr. P.K. Sahoo, additional standing counsel for the opposite party. The matter has stayed before this bench, specially assigned with all the matters, as per the order of the Honorable the Chief Justice in the administrative side, dated code 20.01.2026. IA number 23119 of 2025 has been filed by the state, enclosing copy of the order dated Order dated as passed by the learned, the Honorable Supreme Court. In miscellaneous application number 18 of 2025, in WPC number 114 of 2014, the said IA was filed, the said MA, miscellaneous application was filed, arising out of impugned final judgment and order dated 02.08.2017 in WPC number 114 of 2014, colon, Common Cause versus Union of India. By the order, the Honorable Supreme Court have directed thus. Para 1, 2 and Para 1, 2. Para 1, 2 ଆପଣ କରିଦିଅନ୍ତୁ. Para 6, Para 1 to 6 ପୁରାଟା କୋଟ୍ କରିଦିଅନ୍ତୁ.
1 to 6.
Para. After the order passed by the Honorable Supreme Court, IA number 23119 of 2025 has been filed. Para. The writ petition, the present writ petition has been filed challenging the order dated 4/4/2024 passed by the OP number 2, certificate officer cum collector, Mayurbhanj. In certificate case number 07 of 2018 into bracket 05 of 2018, attaching the immovable properties of the petitioner and directing to take physical possession of the said land, to further directing to put the land into auction and to issue non-bailable warrants. Stop. It is stated in the writ application that challenging the notice issued in the said certificate case, the petitioner has filed certificate appeal number 08 of 2019 before the Revenue Divisional Commissioner, Central Zone, Qatar. The said appeal is pending. Disposal. But Counsel, Mr. Linka, referring to the averments made in the writ application, submits that what लिखे? That one of the grievance raised in the writ application is that prior to filing of the certificate case under the provisions of the Orissa Public Demand Recovery Act, and the further proceeding under the said act, no quantified demand was raised against the petitioner. To support the contention, the Learned Counsel relies on paragraph 4 of the writ application, which is reproduced here. 4 and 5 for them. Yes, which paragraph, Mr. Glenka, you have said that no quantified demand was made?
One of the grounds I have taken, Lord will get at page number 12.
So, cost annexure hochi apanakar 6.
Yes, sir. Annexure 6 is there.
Which paragraph?
Paragraph 2, my lord. My objection.
Paragraph 4, you are referring to minor mineral concession rules? Paragraph 2, page 37.
Page 37.
Yes. And in your case, appeal is still pending.
3 and 4 also. My lord.
In case, your case, appeal is still pending.
Appeal is pending, well. So since this repetition is pending before this Hon'Ble Court, that has not been taken up.
But during pendency of the appeal, what about the demand? What steps, appellate court, what the direction is there? For interim order is there?
No, interim order, my lord, appellate court subsequently rejected the after this. Since no interim order was there, my lord, the collector proceed with the case.
Interim order by this court is not there.
By the appellate court was not there. So challenging that, this writ petition is filed. During pendency of the appeal, when the collector passed the order for
then during pendency of the writ petition, suppose, what the collector is doing?
No, now the collector is
the SLP was filed by whom?
So, SLP, my lord, not
SLP, what? IA, not SLP, IA. Here, we did not IA, miscellaneous application.
Yes, my lord.
Miscellaneous application was filed by?
State of Orissa.
It's not clear. Not clear. As you said, as you said, it is not very clear. You have to examine it.
Yes.
I'll pull out the whole thing from the Supreme Court. I'll ask somebody to pull out the whole thing from Supreme Court. Then we get a clear idea. In fact, if I remember correctly, there was an earlier order sometime in November that in this very bench, that order I'm trying to pull out. I've read that order. That it was brought to the it was also brought to the notice of the Honorable Supreme Court that there are certain cases whose certain cases where our case, like the lessee has expired and the legal heirs who have not been substituted, they were not on record, they don't know anything, and no notice has been issued to them individually. Supreme Court said those cases will take up on 15th of January 2026. So what happened, my lords? I'll find that.
You are also, I mean, Supreme Court has further heard those IAs.
Yes, January 26, it was supposed to be this case. These cases are different. Cases of my cases are different. Kind of cases. I've read that order. I'll bring it. I'll just get that order. Not immediately, but today I think the evening I'll look at that order. Right. This was probably general sweeping direction. Thereafter, it probably delineated two parts. Cross-check also.
If the appeal is pending, then what is the scope of this writ petition?
No, that is also one thing, my lord. Since, my lord, during pendency of the appeal, the collector passed the order on the properties. That is why the writ petition was filed and the interim order was granted.
How many appeals are pending before the appellate authority?
Hello?
Sorry, how many appeals are pending before the appellate authority?
No, so far as the three appeals, my lord. Though three writ petition, I am representing that. So I have instruction how many.
I mean, all writ applications, in where you are appearing, these three appeals are pending.
Three appeals are pending.
So how many total cases? Total number of cases? ছটা আছে কହୁଛନ୍ତି He submitted that. They submitted by Mr. Lenka that in the cases where he is appearing for the petitioners, that is WPC 12358 of 2024, 9263 of 2024, 9624 of 2024, the appeals filed challenging the action of the collector before the appellate authority is pending adjudication. In view of the urgency, that is coercive action faced by the petitioners, they approached it by filing writ application. In your case, appeals are pending?
No. You're in the threshold. You're in the threshold. আমার threshold আছে।
বুঝিপারলি কোন কইলে?
ডিসিরে প্রবলেম ডিসিরে পেন্ডিং আছে আপনি নয়।
কইছেন আপনি তো কইছেন
না না that is pending. This court earlier my friend's clan approached this court. This court without granting only decided that directorate you approach the appellate court and
thereafter
it was rejected. Thereafter proceeded the state proceeded
and thereafter it was rejected पहले court rejected कौन बुझा पड़ियो?
Interim application was first day was rejected. What I found my
sir, what about the writ? We are now considering the writ application.
Yes, sir.
So writ application was rejected.
No. This writ was granted.
So writ is pending, appeal is also pending.
Yes.
And Mr. Pandit has words. He says that at the threshold they have come to court challenging the action.
My counter says no NBW, no possession. My counter says till date.
Oh, suppose you are giving a positive statement, so they will be happy. What is there is nothing to be adjudicated that there is no NBW.
Let them file a rejoinder.
Why they will file a rejoinder? I don't understand this.
Then you will that is up to them.
I don't understand that the court has to direct them to file a rejoinder. You are not answering. What is the annexer? By which annexer you have raised the demand?
Annexer 3 is there.
Shall I record, Mr. Sahoo?
No. Today you are
Annexer 3. Annexer 3 I will record.
Going first time for this Greek Miller.
No, why then? If you are not serious, then why you are making this statement?
No, my
how can
entirely short adjournment or nothing else.
No. Short adjournment because it is they are saying that it is a old case and there is a direction of the Supreme Court.
Sir, Supreme Court.
And the basic issue, what is the demand made by the managing authority?
That is merit of the case. You also will consider. I have no objection to that proposition.
How can you object?
No, I cannot.
Then why you are saying I have no objection to that?
No, I cannot, my lord.
Then why you are saying all these things I don't follow also?
I'm sorry.
Sorry, कौन है वाला फिर? अरे we are trying to understand something. You are not helping us by saying sorry. I have no objection. कौन लिखने? Read application. Mr. Faluj Lanak, senior advocate, along with Ms. Pradhan, submits that the petitioners in the writ applications have approached this court immediately after action was initiated under the OPDR Act for recovery of the dues. It is submitted by the learned counsel, Mr. Lenka, that in the writ applications where he is appearing, there is no quantified demand made by the mining authority raised against the petitioners towards mining dues, which have been sought to be enforced by resorting to the Odisha Public Demand Recovery Act. In response to the said submission made by the bar by the learned counsel for the state was asked to show the demand raised by the mining authority towards the dues under the provision of as applicable. The learned AC 6 and has adjournment. The learned counsel for the petitioner, the learned additional standing counsel, refers to Annexure 3 in writ application number?
First case, my lord. That is 12358.
12358 of 2024. Yes, go. Where it is quantified for what? Because actually bola podi, but still there.
35. Second page, your space 30 towards middle, upper middle, 35 crores, para 6, 35 crores, 40,000, 40 lakhs, 89,600. Para 6, second line. That is the demand.
So 6 he refers to page Annexure 3 of the writ application. जो number ta कहले, हाँ 12358 of 2024. That is a notice. That is a demand notice dated 5/9/2017. Which at paragraph 6. Which at paragraph no, and he relies on paragraph 6 of the said notice. Paragraph 6 is reproduced herein. Yes, Mr. Lenka, he is referring to paragraph 6.
Paragraph 6, my lord, there is lordship may turn to next page, page 32, my lord.
Yes.
There is another demand notice. They are not, till date, they have not quantified the, first they said that.
In response, it is submitted by the learned counsel for the petitioner.
35 crores somewhat. Thereafter, they, without any, they reduce it to 22 crores.
That the demand has been revised, as would be evident from Annexure 4. Notice dated 25/20. Like Mr. Mukherjee, I have to observe that you are standing up and saying something when the court is dictating. So please don't do that.
I am not.
You leave this habit of unnecessarily saying something has no relevance. कौन लिखने? 2012 ଲେଖା ହେଇଛି 2012/2017
2012
ପାରା yes ତାପରେ ଲେଖିବେ the learned counsel for the answer standing counter 6 and has adjournment to answer to respond to the contention of the learned counsel for the petitioner as noted above. Then annexure 5 another demand.
Yes, annexure 5, my lord, another demand reverting to the previous. They have not determined, but quantified, in fact, what is the amount to be paid.
Here, add he further refers to annexure 5, that is demand notice stated. No, this is by the certificate officer.
Yes.
Refers to a certificate issued by the certificate officer dated 5th July 2018. Certificate officer come collector and district magistrate void was. To submit that, the amount indicated by the certificate officer is also further different. The learned counsel for the adjustment standing counsel 6 and has adjourned. ଆପଣଙ୍କର ଯୋଉ anxiety ଟା ରହୁଛି to stand up and say ଯେତେବେଳେ when you are not given time you should show that you are given time and all the effort is that what is being articulated before the court to be reproduced in the record so that you have the ease of going through that.
That's right.
And getting the instruction. They will also have the ease if they have anything.
Disputing.
So
my friend said,
how can you say what you should dispute the court's order? You are not
I want to
record the
actual thing, Your Lordship.
So if you are ready, then you submit. When you are saying that I am seeking adjournment, when I am asking you to respond to him, you are sick. So I have to record. I am recording that. I think nothing better can be done than this than recording whatever is deliberated. So
trying to say the factual thing. What I received today from the record.
Then
there are two.
Then how can you submit on their behalf?
No, I am not saying.
After they say something, why are you interrupting? After they say something, why are you interrupting? Because that is
counter says other. They are saying something. Counter says other.
What is the submission I am on the learned counsel for the additional standing counsel again and again says that the counter says something else. Should I record this? Then why you are doing this? I don't understand. Either you refer to the counter so that I can record your submission.
That I was trying.
But you are just going on interrupting every time something is dictated, something is discussed.
May I pardon, my lord?
Yes. ଆପଣଙ୍କର କୋଉ ମ୍ୟାଟର sir?
ମାନେ ଆଇଟମ 31 ଏଣ୍ଟ୍ରି ମର୍ଡରଟା ଥିଲା।
नहीं କୌଣସି ମ୍ୟାଟର କିଛି ଏଣ୍ଟ୍ରି ମର୍ଡର ଭ୍ୟାକେଟ ହେଇନି। ଆପଣ ତ ଏଣ୍ଟ୍ରି ମର୍ଡର କଣ ଭ୍ୟାକେଟ କୋଉଠି ହେଇଛି? କିଛି ତ 24 ନା 25 ଯାଏ ଯାଇଛି। 31 ରେ କଣ ଭ୍ୟାକେଟ ହେଲା ଭାବୁଛନ୍ତି? We are on other matters actually. The time is over. That was till 3:15. Unless you are sure of what you are answering, for that a lot of effort is being made. That is to assist you also. And they also know what they have submitted and whether the line of discussion is drawn clearly. About barambar interrupt kale kono counter says something else.
One stand is taken by petitioner saying something to court, Millard. We have answered it in my.
So you say that. So you say that. You say that. Start telling.
I was telling you because your lordships are adjourning to other day also. So preparation of the other things have to be required.
No, either Mr. Sahoo, you are not doing charity to me.
No, I am not saying that.
So don't be so humble and so charitable to me. If you are answering, then straight away come to the counter.
Your lordship see para 11. I need to not the time today. That is why I am saying.
Then what is this attitude? I don't understand. Every time when I am dictating, you are interrupting. I am just recording their submission. You will decide what will be recorded by the court.
Your lordship's query is there. That is my responsibility to show your lordship. Your lordship's asking there are two demands.
Sir, I'm waiting for the fast tag. How can you say my query is there?
Your lordship's asking me to.
I never asked you.
That's the direction what I lordship.
I have to.
Yes, that is there.
The Lordship Counsel for the petition, additional standing counsel submits that.
11 is there. Your lordship's query.
So you answer that. Have I recorded that you answered anything?
I was trying to express.
So today when you answer, why you are I have said the Lordship additional standing counsel 6 and has adjournment. I will not grant you adjournment.
I will answer.
I don't understand this. What you want actually, Mr. Sahoo? I don't understand. Yes, Mr. Lenka, what you could follow, I am unable to follow him also. What he wants? Whether you want adjournment or you want to argue the matter.
Fix a date.
Whether you want adjournment or you want to argue the matter.
I will ask for an adjournment. Next.
Then why you are taking time for that?
No, I am not.
What is the difficulty if the court records the submission of the petitioner? That also I am unable to follow. What is your difficulty? Court will not record that.
What correct?
Yes, Mr. Palit, anything else to be recorded?
My points are little different from my learned friend's points. So, I have said that we had no opportunity to oppose the demand. We were never even substituted properly. There was no notice of substitution.
It is submitted by Mr. Palit, learned senior advocate. Mr. Palit,
we were not even substituted.
What I am doing, I am passing one order. Instead of taking the matter separately, passing one order for the timing.
My part, Lordship may limit it to this. That I have received it, my submission, that I received the counter affidavit.
I'll indicate that.
And I'm just asking for now 3 weeks time to file.
When you opened your statement, you said that I have received the counter.
Only because Lordship wanted to know about the case, I was just trying to.
Obviously, because a special bench is assigned and it is open. So I need to understand because the first question that why the MMDR matter is coming before me. Because you said very clearly that it is a major mineral.
Major mineral and context of OPDR.
By Mr. Palit, the senior advocate, that in the writ application where he is appearing for the petitioners, specify for the writ number. Mr. Lenka, you can take your seat. That his submission would be that the petitioners were not given any opportunity.
No notice, prior notice.
No prior notice was given. Some of the petitioners were not substituted as the legal heirs of the past oblique earlier leaseholders.
No notice of substitution also.
There is no notice of substitution to substitute the petitioners as legal heirs.
Demand also is equal.
For demand to be raised against them.
In demand also we have not received. No, we have not been served with the demand also.
It is submitted that the demand notices were not received. The demand notices issued by the
were not served on
Department of Mines were not served on them. जो लिखिंग द लॉर्ड एडिशनल स्टैंडिंग काउंसिल 6 and has adjournment সেটা কাটি দিও সেই লাইনটা রহিব in response the lord additional standing council submits that the contentions raised by Mr. Lenka lord counsel for the petitioners have been answered by the counter affidavit at paragraph 11.
But different paragraph 11 is. And so far the demand is already there, other paragraph there.
You gather your thoughts and be specific because you are saying that whenever you are saying that, so it's standing up. So now you want that you have answered, so let it be recorded. Yes. Counter affidavit filed in?
Filed by OP number 214.
WPC
In the first case, my lord.
in WPC 12358 of 2024 by the OP number 2 and 4 through the Deputy Director Mines Baripada. He relies on paragraphs
Paragraph 5 and 11 also.
5, 11.
Demand notice was, yes, very clear. These two questions are also.
5, 11, which are reproduced here. Have you filed counter in Mr. Palit's writ applications?
Yes. Yes.
Not filed.
No, he filed. Yes, filed. I'm seeking my 3 weeks time to file a reply.
The Lord Senior Advocate, I'll try to structure it better because it has been interrupted so many times. It will be structured. Definitely.
Do it at
It will be a continuous thing.
Do it at leisure.
So the Lord Additional Standing Council submits that he has filed counter in response to the writ applications, so and so. So Mr. Palit
as well as the vacation of stay petition also.
And the vacation of and has also filed a petitions
for vacation of
interim order of stay.
On 22nd,
Mr. Palit Lord ଆପଣଙ୍କର କାଉଣ୍ଟର ଆଉ ସେଥିରେ vacation ବି stay ଫାଇଲ ହେଇଛି
Vacation. 22nd to
the copy of the said application was served on the Lord Instructing Council on 22nd
12/25
22/12/2025 and further time may be granted to file reply thereto. Mr. Lenka, Lord Council, submits that he has received a copy of the IA seeking vacation of stay. Can ଆପଣ counter ଆଗରୁ file ହେଇଥିଲା?
counter ଟା ଆଗରୁ file ହେଇଥିଲା
10/7/24.
Vacation of the IA for vacation of stay, public interim order, and he shall file response thereto. Yes, you suggested date, Mr. Sahoo. What is your date? When next?
Convenient.
Lordship convenience is not printed in the calendar.
I have no choice.
No,
I said that because of the
Lordship convenience, if they start printing, I'll be speaking.
I said that yes, there is time.
No, I'll record that you are not suggesting a date.
Not record. This
I have to. Let us know on the form of the judicial proceeding. We have made submission in the form of the judicial proceeding today, sitting from 315. What we are doing, it is neither here nor there. The Lord Additional in response.
I would
for the next date of
small.
No, there is a purpose because it is directed by the Supreme Court. So at times we have to be subtle also.
Absolutely.
The Lord Additional Standing Council refers to the court. The Lord Senior Council, Mr. Palit and Mr. Lenka, suggest the matter to be listed in the week commencing
last week of February. 23rd.
In the week commencing 22/2/2026. Yes, what is your objection to 23/2/2026?
23rd.
1 week earlier. Already.
ତାହେଲେ ଆପଣ କନଭିନିୟନ୍ସ କାହିଁ ଲୋକ କୁ ଛାଡି ଦଉଛନ୍ତି?
Sir, we cannot.
I can continue today also.
I leave it to Lordship.
No, I cannot. You cannot leave it to me. I will record. I will record that it is not at my choice.
Subject to other.
Sir, we cannot be so pretentious. We cannot be so pretentious. There is a limit to being pretentious and making fun of a judicial proceeding. So, the Lorded Counsel at this stage, the Lorded Additional Standing Counsel again submits that the matter may be listed in the week commencing 16th February 2026. Accordingly, the matter shall be listed in the week commencing 23/2/2026. Marked at ଆପଣ ସେଟା ସ୍ପେଶାଲ ବେଞ୍ଚ ଟା ହଉଛି ଏଟା ସେପାରେଟ ବେଞ୍ଚ ହବ yes
ସେପାରେଟ ନମ୍ବର ବି କରିଦିଅନ୍ତୁ
ଆଜ୍ଞା
ସେପାରେଟ ନମ୍ବର ବି କରି
ନମ୍ବର ହେଲେ ବେଟର ହନ୍ତା
I am sorry that
no actually that yesterday I also asked that why you are making it together but it was so late so they could not list it properly. The registry shall list the matters indicating a separate serial number for each of the cases.
Better for dictating orders also.
Yes. No, I'll take care of that.
Nice. Grateful. Now interim orders be extended.
Interim order passed in all the matters shall continue till the next date.
Grateful.
Yes.
Grateful. Okay.
केबे डेट करिवे?
Urgent copy of a lordship order.
Please. 27 शुक्रवार 26 रखुनांते स्पिल ओवर एंड स्पेसिफिक डेट कर दियो 26 को 26/2 मिस्टर 26/2/2026 ठीक है थैंक यू मार्क दैट 2 PM यस नाइन बट आपण एटा गोटिए लिस्ट हो केवल अन्य मैटर मिसेबेन यस
Great. Urgent copy of a lordship order.
Yes. Urgent certified copy. Parties to act upon the order uploaded in the official website.
Great.
That's okay, sir.
Separate.
Ajita batch हे जाऊ. अपन जेतु कहीं separate colony काली should have been a separate
cause of action था.
तो separate हे जाई थाउ. At least Mr. Palit करो 3टा matter, Mr. Lekha करो 3टा matter. Mr. Sethi, you are appearing in some matters.
Yes, your lordship. T5.
अपन लिखिक दे दियो जोड़ा का आपनकर माने रीट पिटिशन नंबर लिखि दियो मिस्टर साहूकर जोटा आपन जोड़ा लिखि दियो
It's also नहीं इधर फर्स्ट लिस्ट
स्पेशल लिस्ट ना नहीं
स्पेशल लिस्ट था
एथरे किछि नहीं ओके देन लीव इट यस